of the Appeals Court, now sitting at possible equipment for the Commonwealth. God mayor, give me your attendance and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Sachs. To my left is Judge Smyth. And we are your panel on the 6 cases we're hearing today. I know we have a lot of veterans here in terms of practice, not service. So I will not go over the rules except to say that you each have 15 minutes per side, and there's no opportunity for rebuttal. I want to assure everyone that we have all read the briefs and the relevant portions, at least, of the record. So we are familiar with both the facts and the legal arguments. So since 15 minutes is not, in general, a great deal of time, we urge you to cut to the chase to the extent possible. And if you don't, we'll be happy to help you with questions. That said, if you're done saying what you have to say and there's still time left on the clock, there is no shame in sitting down. As one of our former colleagues used to say, if you hit a home run, you don't have to run the bases twice. And with that, I will call the first case of the day, 2023 P157, Commonwealth versus Cruz. Attorney Norris.
Thank you. Good morning. My name is Chris Norris. I'm from Ipswich, Massachusetts. I'm speaking today on behalf of Mr. Cruz. I'm not a veteran in any way, so any mistaken form is...
Could you tilt the microphone just in your direct? It's directional. So perfect.
So any mistaken form is not meant as disrespect to this really remarkable court. I have one issue with respect to Mr. Cruz's trial that I'd like to focus the court on, and that is a video recording that was admitted and played and then replayed during the testimony of Leslie Lemus. And I'm suggesting to the court that while there was no issue with respect to that video being admitted, being played for the jury in the first instance, in the second instance, playing that video for the jury was distracting. And I'd suggest to the court that it risked having the jury conflate what was depicted, which is fair to say was an assault and battery, with a strangulation, which was not depicted. And I don't think that was made clear.
But the victim testified that the strangulation that she alleged happened before the video.
Certainly.
So why wouldn't the jury accept that?
Well, I think that she did testify, but playing and replaying that video still runs the risk of the conflation I've been talking about. And I'm just speculating here, but as I sit down and reimagine this trial, I think that the Commonwealth realized they have a credibility issue with respect to Ms. Gomez. And one way to fix that credibility issue is to focus on, repeat, replay, and direct the jury's attention.
But you appear to acknowledge in your brief that once it was admitted in evidence, the jury could play that as many times as it wanted.
Oh, they could play it as many times as they wanted during deliberations, and I don't think there's really any strong mechanism to police what the jurors are doing in that deliberation room. But the issues that I want the court to focus on would be akin to a situation where, imagine if in the closing argument, the Commonwealth summarizing the evidence had said, Ms. Gomez testified to X, Y, and Z, and played the video. And then they said, and Ms. Lemus testified to X, Y, and Z, and then they replayed the video. I think there would be an objection there, and again, I think that replaying of the video in that situation, it would distract and confuse the jury. it's cumulative, meaning that the replaying doesn't add anything to what the jury would have observed, heard about, heard described in the first instance. And as I said before, with respect to the Commonwealth fixing a credibility problem, I think there's a propensity problem here as well, which is that the Commonwealth, I think, realizes that Ms. Gomez has a credibility issue. How do you get past that? Well, you replay and repeat and draw the jury's attention to this instance of bad conduct by Mr. Cruz.
But isn't the bad conduct the whole point? I mean, how is there not better evidence of at least one of the crimes charged than a video showing it in progress?
Well, there is, that is the evidence. The video depicts an assault and battery. It doesn't depict a strangulation. And as you said...
And tell me if I'm wrong, the Commonwealth never claimed that it depicted the strangulation, did it?
Yes, they did not, and if memory serves in the closing argument, they made a passing comment that Ms. Gomez had testified that the strangulation happened earlier. But the strangulation's not depicted in that video, and what I'm suggesting is that playing, focusing on it, replaying, not only fixes that credibility problem with Ms. Gomez, but it also risks the jury confusing what they're seeing because it is quite a chaotic scene that's depicted in that video.
Understood, but doesn't that cut the other way in that when you have the daughter on the stand as the one who took the video and therefore was looking at the exact scene that she's photographing, there's value in having her walk through what is being shown on the video because it's what she observed.
And I guess I'm wondering and questioning what that value is. That is more significant.
You pointed out that what was being shown is somewhat chaotic, which is also why I, for one, think the jury probably replayed that video many times.
Sure, and they, it's certainly in their purview to do that during deliberations, but to go back to your question, what is the value of replaying that during Ms. Lemus's testimony? Even if it is a chaotic scene,
well, there was some confusion in the victim's testimony. She said at one point, oh, I think that might be the defendant's brother in the background, or maybe his cousin, I'm not sure, whereas she had initially identified the people in the video as herself and the defendant. Right. So once she expresses that confusion, isn't it a perfectly valid use of the video to have LL come back and say, no, the people in the video are my mother and the defendant?
Well, I think that's repetitive again when, before the admission of that video, Ms. Gomez testified, there are two people, me and Mr. Cruz, and that was before it was admitted. That's how the video was admitted in the first instance, because she was able to identify.
But then she gets a little confused, or at least there's some confusing testimony about who is in the video. Why can't the Commonwealth clean that up with LL?
The Commonwealth could clean that up by having Ms. Lemus testify about that scene that she was present for and took a video of. But I think the probative value in doing that and having her testify is outweighed by what I've described as the prejudice of replaying that video, which is it's going to distract the jury, it's repetitive and cumulative, and ultimately I'm suggesting that there's a propensity issue with replaying it in this continued focus on it and directing the jury's attention to that.
You argue that the video is very powerful, and speaking only for myself at the moment, it is very powerful. It is very disturbing to see a violent assault filmed in real time. But is there anything extraneous about what it shows that makes it unfairly prejudicial as opposed to merely prejudicial?
Well, it's not extraneous, or there's absolutely nothing extraneous with respect to the assault and battery, because that's what it depicts, an assault and battery. It doesn't depict the strangulation. And I think that's my major concern, and that's what I'd like the court to focus on, where you have a witness testifying that there was a strangulation. It's not depicted in that video, and then you have this chaotic video. And while the Commonwealth did, in their closing argument, point out that the video is from a time after the strangulation occurred, there was no instruction to remind or direct the jury's attention to that fact.
Can I just get clear? There was a charge of domestic assault and battery here.
Yes.
Doesn't the video depict that?
Yes, it does.
So what's wrong with that? What's wrong with, I mean, it's not as if the video depicts uncharged conduct.
Well, there's nothing wrong with playing that video because it's directly probative of the assault and battery. And so what I'm suggesting is Ms. Gomez testifies, Mr. Cruz committed an assault and battery on me. This is what happened. The video is directly probative of what she's saying. I mean, it's a lifetime video of that assault and battery happening. My concern is that it doesn't depict a strangulation, and when the Commonwealth replays it during Mrs. Lemus's testimony, how is that probative of anything that hasn't already happened during Mrs. Gomez's testimony?
It has to be substantially more prejudicial than probative under 403, right?
And I'm suggesting that it is. In the first instance, during Ms. Gomez's testimony, that video passes that test, the 403 balancing test. But again, and this is where I point to the old chief case, I don't think that the balance between the probative value and the prejudice is static. It changes and shifts as the evidence develops during the course of a trial.
You're not suggesting that Old Chief is directly applicable here, are you? Because there was no offer to stipulate.
No, I'm suggesting that in Old Chief, Justice Souter points to the fact that a piece of evidence isn't static in value. It, you know, at one moment during the course of a trial with respect to one witness, that piece of evidence might pass that 403 balancing test. And then later, as the trial develops and there are other pieces of evidence, other testimony, the balance might shift and it may not pass that 403 balancing test, which is what I'm suggesting happened here during Ms. Lemus's testimony. In the first instance, when Ms. Gomez testified, she talked about what happened. The Commonwealth played that video. She identified the parties in the video. Commonwealth played it for the jury. That depicted an assault and battery. What I'm suggesting is then later in the trial, during the testimony of Ms. Lemus, the probative value undue prejudice balance shifted. Because what was the purpose? And you can say, well, the purpose was, as you rightly said, the purpose was, well, the Commonwealth can clean up some of the chaos. But why can't Ms. Lemus testify about what she's also seeing in live time to achieve that purpose? Playing that video again was unnecessary, and that's a problem, but it's not a problem that requires reversal. It was also distracting, and again, I'm pointing the court to the issue where the jury would conflate the assault and battery with the strangulation. It's cumulative, it's unnecessary. There isn't really any good purpose to play that again. And then finally, and I'm speculating here, I think that playing that video again, focusing on it, referencing it, that solves what the Commonwealth perceives as a problem at that trial, which is that Ms. Gomez had a credibility problem, okay? And the Commonwealth could have stood up and said, well, even if you don't believe a word she says, we have this video, it's an assault and battery. But playing it, referencing it, replaying it, what that does is it allows them to say, well, Mr. Cruz committed an assault and battery. You can see that with your own eyes. You don't have to believe a word she says. So this bad guy likely committed a strangulation.
Can I stop you for a sec? How do you address the fact that the jury acquitted him of the most serious charges?
Well, because they didn't believe her. That's exactly what makes me think the Commonwealth recognized that they had a credibility problem. That and the fact that they null-prossed a number of serious indictments before the trial even started. I mean, the jury clearly didn't believe her. And that goes right to the heart of my point about the conflation. The jury didn't convict him based on what she said. They convicted him of assault and battery based on what they saw in that video. But what they didn't see is a strangulation. If her testimony alone was enough, they would have convicted him of all the indictments. But they didn't do that.
You've got a minute on the table if you would like to use it.
Thank you very much for your questions. Really, it's really wonderful to be here. It's a beautiful court, and thank you. And
We're glad you like it. Thank you very much. We'll hear from the Commonwealth.
Good morning, Your Honor, and may it please the Court, Aaron Stoudinger, Assistant District Attorney for Middlesex County on behalf of the Commonwealth. In this case, there was no error in admitting the video, of playing the video, replaying the video a second time, where the video was necessary and highly probative to contextualize the victim's daughter's version of events, her own independent version.
Can I just ask you to flesh out what you mean by contextualize? Because you use the word many times in your brief, and I'm not entirely sure what it means in this context.
And what I mean by that is that it is, she has her own independent version of events, her own independent witnessing of this event. The video is taken from her perspective, and so it is appropriate to play this video in conjunction with her testimony in order to demonstrate that the exact things she's saying occurred are what's being depicted on the video. And so in that regard, I mean, I was trying to avoid saying corroborate because it's not necessarily a corroboration of her testimony. It's the fact that she is witnessing these things and there is a live video of the events she's describing. So she is permitted to play the video that she took in order to contextualize her live testimony. And that's what I meant by that, is that this is simply a playing of her live testimony, her recollection of events. And so just as it's appropriate to play it with the victim's testimony, it's just as appropriate to play it with the daughter's testimony. And I would touch briefly on the things that this court has highlighted, that it was highly probative. It was direct evidence of the assault and battery on a family and household member. It was highly probative evidence of the defendant's state of mind, both after the strangulation and during the commission of the assault and battery of a family household member. And important to note that although he was acquitted on the charges, this is also probative of his state of mind prior to one of the counts of alleged rape. And so it's coming in for those purposes. And again, it's just highlighting or just reiterating that it is important. It is probative of identification of the defendant. The victim did equivocate slightly on her identification of the parties in the video, so it was appropriate for the daughter to testify regarding who the parties were to shore up that identification. And so for all those reasons, there was no error in admitting it. I would note that in any event, there is no possible prejudice faced by the defendant from replaying this video a second time. As this court has noted, the jury are free to play it as many times as they want during deliberations. It's common practice to replay videos and display evidence during closing or at other times during a trial. I just don't see what prejudice this defendant could have faced from replaying a properly admitted piece of evidence that the jury was free to have in the deliberation room and could have viewed as many times as they wanted. And if there are no questions, the Commonwealth would rest on its brief.
Seeing none, thank you very much. The case is submitted.
Thank you, Your Honor.
Our second case of the day is 2023 P636, Commonwealth versus Rivera. Mr. Benyon, welcome back.
Good to see you. To the presiding justice, may it please the court, good morning. I know what you're thinking. Are we still doing Andy Dukin cases? And the answer is apparently so. The government's rebuttal argument is simply that their case was so strong that we can move forward and that the judge's decision below was correct. However,
I'm not sure that's entirely fair. They also say your client, and especially his wife, got a lot out of the plea deal, and therefore, in combination with the strength of their case, there is no prejudice.
I'm going to put a pin in that. I'm going to come back to it, though. But I do want to point out the fact that the government's contention, at least with respect to the strong case, only makes sense if you initially buy the fact that the substances were illegal in the first place, which is circular reasoning. It doesn't make sense. We have a statute on the books about illegal drug or fake illegal drugs, what we usually call burn bags. You don't usually see these types of cases. I would be surprised if any of you have ever had a case like this come up, because usually if somebody is burned by purchasing illegal drugs, they don't usually go to the police. But there's still a law on the books because it happens, right? Baking soda might look a lot like powdered cocaine, oregano might look like marijuana, and so the whole substance is that the government needs to prove the chemical composition of the substance. Justice Sachs.
Thank you. So if this is baking soda, where's the baking soda package in the house? If this is oregano, where's the oregano package? Why do we have a cutting agent? Why do we keep the baking soda in the safe? Why do we risk keeping an unlicensed gun around to protect these everyday substances? Why do we have cinnamon sticks with the largest amount of cocaine, the 95 grams? Why would your client give his real first name to the buyer if he's selling fake drugs? Why would he waste money on a digital scale if he's selling powdered sugar or oregano?
Any more?
Yeah. Why would he have such a large quantity around, indicating that he intended to stay in business for a while? I mean, if you're selling fake drugs, maybe your victim buyers don't go to the police, but one of them is going to come back to you.
So the obvious answer is that if in an illicit trade, you don't always just sell fake drugs. You don't always just sell real drugs. It can be a combination. It usually is. And I think that makes the most sense.
Is there evidence of that?
Is there evidence of that? There's no case law that says that that somebody who is selling narcotics would only sell a true narcotic. But I think reasonable people would understand, especially three gentlemen as seasoned as yourselves who've gone over so many cases. I hope that when I say that it's not unreasonable that somebody who is trying to be a drug dealer or who is a drug dealer is always going to sell good drugs and not sell fake drugs. Whether my client is a drug dealer is irrelevant. The case is about whether the drugs seized were actual drugs. Would you at least agree with that?
I mean, ultimately, it's about whether he would have pled guilty.
You want to come back? All right, so let's go to your point. I'll pull a pin out of that one and go to it. Government, so when somebody is indicted and they face criminal penalties, people often act in their own best self-interest, to borrow a phrase from Adam Smyth. People don't always act in a way that comports with normal societal justice, or especially what judges and lawyers think of as justice. If you go to page 30 of my brief, I have a nice quote for you. So as Justice Scalia noted, plea bargaining presents a grave risk of prosecutorial overreaching that effectively compels an innocent defendant to avoid massive risk by pleading guilty to a lesser offense or to the offense if they're getting something. In other words, once there's an indictment and once the government and the defense are engaged in bargaining for what the plea deal is going to look like, it's not always, a defendant doesn't always just plead guilty because he is guilty. I hope that's not unreasonable. I hope, seasoned as you are, you would understand the pressures that come from an indictment. I'm not speaking out of turn, right? You would understand that, right? Justice Scalia's quote isn't falling on deaf ears, right?
We hear what you're saying.
Okay, good. So all I'm saying is, if there's a possibility that the drugs are fake, and maybe he was selling good drugs yesterday and was selling burn bags today, the point still is that the government has to prove what was seized was a drug, and then passing through Annie Dukin's hands, the question that becomes, would a defense attorney and would the defendant feel comfortable about going to trial? And I don't know about you, but speaking as a defense attorney, I would feel pretty comfortable going to trial if the government, the only witness they have is Annie Dukin, who's going to testify as to the substance.
But what if if we're going back in time and pretending that defense counsel knew about Annie Dukin, that this egregious governmental conduct had been disclosed, the Commonwealth would have known as well. Would the Commonwealth have called Annie Dukin so that she could be subject to a withering cross-examination?
Well, if you reverse, we don't have to guess. We'll hopefully figure that out. The idea here is that defense counsel put in an affidavit saying that had he known, he would have...
I'm asking you, is it logical to think that this withering cross-examination ever would have occurred?
That the withering cross-examination would not have occurred?
Is it logical to think it ever would have occurred so that, any defense lawyer worth their salt would have just relished the opportunity to call
I'm just a humble defense attorney. I don't know. It's the government's call whether they're going to seek a trial or not on their indictment. It's not defense counsel's call. But if defense counsel...
If they proceeded with trial, would they call Annie Dukin? And the suggestion by my colleague is no.
Right. And that's the only way you're going to prove those substances. They could send it out to be retested, but again, it's still... that just still opens the same problem, having gone through Annie Dukin's hands.
How?
Because sometimes, so if you remember the report, sometimes she would take cutting agents and she would take a little bit of cocaine, put it in there, mix it up, because it doesn't matter. No matter what the dilution is, it's still considered cocaine, right? And so anything that's passed through her hands is still suspect and would still allow a wonderful, withering cross-examination by any competent defense counsel.
What's your argument about the 2 years of probation at pages 24 to 25 of your brief? I couldn't quite follow it. Are you suggesting that had the defendant known of Dukin's misconduct, he could have negotiated for a little bit less probation?
Oh yeah, I get that. That's more just me trying to flesh out all the problems that kind of can occur when you have a government witness who is simply not credible. Whether defense counsel is going to negotiate, or what the defendant would be amenable to pleading to. Again, there are a lot of variables, right? It depends on how the government would want to proceed. It depends on how bad, under the pressure of an indictment, the defendant might want to resolve the case. I guess it is a little unclear, but it's just to show, I guess, in my mind, the many variables that come. But in the end, what you're looking at is the government can't prove and couldn't have proven the substance. And that's the whole heart of this case. You don't know if it was a burn bag. And that's the whole point. The whole issue here is we put such a premium on the high standards. So going back to Blackstone, the idea that it's better that 10 guilty men go free than one innocent man go to prison, that's embodied in the idea of proof beyond reasonable doubt. It's supposed to be this high bar that is supposed to weed out those questionable cases. And in this instance, you have a very questionable case because it's an illegal drug. It's an illegal drug only if you believe it's an illegal drug. There's no evidence that could prove it, having gone through that woman's hands. And again, back to your point, Justice Milkey, it's not unreasonable for somebody to plead guilty in that situation because remember, back then, they didn't know Annie Dukin was the problems. It's not unreasonable that somebody is going to plead guilty even if they're innocent. I hope
Let me ask you this, counsel. To demonstrate a reasonable probability he would not change his plea, the judge in this court rely on the affidavits filed, correct?
That's correct.
And counsel filed an affidavit. He's done a lot of work. He just doesn't have a specific memory of this case, which is understandable. It was a while ago.
Yeah, it was.
But defendant doesn't have a very good memory of this either, which is harder for me to understand. It was a while ago, but this is a significant event in anyone's life. And for a defendant to claim he doesn't have a very good memory of it, I find strange credulity.
So I guess I would answer that question this way. I think we're all familiar with the idea of memory as it relates to the legal profession. We like to think of a person's memory as a snapshot in a camera, and it can be recalled years later, and we all know that that's not the case. Is that correct? Have I spoken out of turn? Do we all understand that memory doesn't function?
No, I think you should focus on answering the questions, not asking them.
So I'm going to assert that people's memory is not like a camera. And let's suppose that he was a drug dealer. On Tuesday, he was selling real drugs. On Thursday, he was selling burn bags. And maybe a few years down the line, it's not unreasonable to suspect that he would be like, or he would think, I don't have a memory of whether it was Tuesday or Thursday, and I don't remember what I was selling.
Oh, he doesn't say he doesn't remember the facts of the case. He says he doesn't remember the plea negotiations or the plea hearing. Would it be fair to expect him to say something about whether these were drugs or not? Or is that just totally out of bounds?
No, because the initial question, that would be the next question if it's reversed, if the judge were allowed to go to trial. But in this case, we're only looking at those standards of whether we're going to reverse the plea because it was an Annie Dukin case, which is, they're set out in the brief and you look at them and determine.
Right, but would this be a stronger case if his affidavit had said, these weren't drugs, I was selling powdered sugar and oregano. I tried to tell my defense attorney that, but he said, once the drug lab gives its certificate, you're dead. And so we really, our best option is just to negotiate the best plea. Now, of course,
well, that would have been a great affidavit to get.
Well,
but in this case, I have what I have, and I think the idea was that defense counsel was just trying to show, and the affidavit of the defendant was just trying to show that, at least in the plea negotiations, they don't really remember, and that might be completely reasonable. I'm not sure how much of a plea negotiation you would remember a few years down the line. In the end, usually it's more important what the plea is and what you actually are going to plead guilty to. But here we're much more interested in, was it reasonable if defense counsel said in his affidavit, if I'd have known, I would have gone to trial. And the defendant saying, if I'd have known, I would have gone to trial. In this case, I think it's completely reasonable. And I think that they would have gone to trial. And it's not a strong case, and it's not unreasonable that somebody would plead guilty to a crime they didn't commit under these facts.
Let me ask you about the strong case. And the question is how you, kind of the framework, how you analyze evidence in considering whether or not it's a strong case. In this case, for instance, there was a number of substances, accoutrement seized during the search warrant, and in the search warrant, motion to suppress was denied. So that evidence likely would be admissible. Let's just.
Yes.
But there was also a statement from the buyer who said, I just bought some cocaine from that guy. How do you evaluate that evidence? Do you see that evidence as factoring into our decision whether this is a strong case for the
Did he try it? I mean, that would almost be like not a police, what's the field test, right? Did the person field test it? Or are they just presuming that it's cocaine?
It's a different question. It's is the buyer's admission to buying cocaine from the defendant, is that worth anything in the analysis of the strength of the case?
No, because again, the whole point of the law is it was an illegal drug or it wasn't. If it wasn't an illegal drug, all the accoutrement and the theater around the buy would be to a burn bag. Did that make sense? All right, I'll rest.
One further question. Could the mandatory minimum drug sentences have run concurrently if he had been convicted of or pled guilty to the two trafficking charges?
Say that again, please.
Could the sentences on two trafficking charges have run concurrently if he had pled guilty or been convicted of them both? I'll ask the Commonwealth the same question.
As an appellate lawyer, I always say I never shoot from the hip, but, and I would go and research that, but my answer, I think, is yeah, could.
They could. Okay, thank you.
Thank you very much. We will hear from the Commonwealth.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. I'll just start off with Justice Sachs' question, and I do believe the sentences could have run concurrent as well, which would have had the defendant facing up to 45 years in state prison, which is obviously part of the reason why the Commonwealth argues.
Well, that's if they ran consecutively, right?
Correct.
But they could have run
But they could have
concurrently.
run concurrent.
So it wasn't as if he was avoiding mandatory minimum consecutive sentences by pleading down the one of the trafficking charges.
Correct. I just turn back, I suppose, to the strength of the case as well, because I do think that is the Commonwealth's biggest hurdle in this case. I would concede that on the record, there's really no evidence to confirm that the alleged heroin was heroin. I don't believe there's anything on the record outside of the drug certificates to say that the nature of that substance related to count 3 was what the Commonwealth alleged it was.
No evidence of field testing?
No evidence of field testing, Your Honor. However, in that case, I think even if count 3 is disregarded, it doesn't really change the Commonwealth's analysis here, because the count 3 and count 4 charges were concurrent, and they were both probation charges. So I think even in a situation where count 3 is gone, we still have the defendant having the same sentence. As to the nature of the cocaine, I think the court has raised a good point that if we were back in 2007 and the ADA were prosecuting this case, it's highly unlikely that he would have called Annie Dukin to testify. I also believe that in a situation where we have trafficking charges, the Commonwealth would have pursued any avenue to prove its case at trial. And Justice Smyth raised the the buyer of the drugs. I think the fact that the buyer told police he purchased cocaine from the defendant, although not exactly analogous to Resende, we have what amounts to an admission, and I believe the Commonwealth could have gone forward on that, as well as all of the indicia of trafficking that was found at the defendant's home. It's also extremely significant that in considering the bargain that the defendant received, the charge against his wife was null prost in.
How are we supposed to factor that? Because, I mean, part of the somewhat odd exercise here is to try to get inside the defendant's head and figure out what he would have done if he had known of the Dukin problem, for lack of a better term. And Mr. Benyon makes a non-trivial argument that he might have rolled the dice given the problems in the evidence and the possibility that the jury would acquit him. And yet, you know, a big part of the calculus here may obviously have been the arrangement with regard to the charges against the wife. And on one hand, it seems perfectly reasonable for the Commonwealth to offer this. On the other, one could argue at least that there's some unfairness. You know, if he was going to roll the dice, theoretically, on his own plight, you know, perhaps he wouldn't because of the deal offered the wife. So I'm struggling a little bit personally with how to think about that.
I do understand that, and that is a consideration. However, it's still the Commonwealth's position that it was a benefit that the defendant received because his wife didn't have to face the charges. But I do understand it's a very difficult situation.
Are there any cases that you're aware of that address this issue?
Not that I'm aware of, Your Honor. If there are no further questions, I rest my brief. Thank you.
Thank you very much. The case is submitted. Our third case of the morning, and the last before we'll do a brief mid-morning break, is 2023 P, put on my glasses, 349. The case is Commonwealth versus Tremblay.
May it please the court, my name is Michael Chinman. I represent Albert Tremblay in this appeal of this conviction. Every prosecutor knows the untouchable third rail of closing argument is commenting on the defendant's silence. You can't say, if he didn't do it, why didn't he just say so? And that's essentially what the trial prosecutor here did. She said, if he didn't do it, why didn't he just say so? Instead of implicating his nephew as another relative in the house, implying he could have done it. That is an untouchable third rail because if you do it, it comes with severe consequences, and those severe consequences are warranted here. There should have been a mistrial. It was requested. It should have been allowed.
Was the prosecutor commenting on his silence? Was the prosecutor commenting on his silence or on what he was saying and what it would have been natural to say in those circumstances? Well, I didn't see an objection here that this burdened, in the brief, maybe I missed it, that this burdened the defendant's Fifth Amendment rights. The objection was that it misstated the evidence or that it was contrary to evidence that the Commonwealth had successfully kept out.
I think it comes at the Fifth Amendment issue from the other side and says that, in saying that I wasn't the only relative home, why didn't he say I didn't do it? And it's even more egregious than commenting on silence because it does misstate, because he did say I didn't do it. He denied explicitly committing these acts. And
so why wasn't that cured by the belated stipulation? Now, maybe the belated stipulation caused some other problem, like the defendant's inability to argue it in closing, but why didn't the jury being informed, yes, the defendant denied it, cure whatever suggestion could have been drawn from the Commonwealth's argument?
Well, as you said, there is a constitutional component to closing argument, and the defense was prevented from making an argument about it.
Okay, but what I'm asking is, why didn't it cure the problem created by the Commonwealth's closing?
Well, a stipulation, if I could, is kind of the stepchild of evidence. It doesn't come from a witness. It doesn't give the jury an opportunity to evaluate credibility.
The evidence was never going to come in, right?
What?
The evidence that he denied it? I mean, he
It
wasn't...
It didn't come in, but it could have come in. It could have come in. I think it could have come in as a statement as part of completeness about the other statements. There were many statements that the Commonwealth did put in from the police interview when he said that. So it could have come in, but you're right, it didn't come in. But
Can I, just on the same point about curing, I would actually go one step farther and say, why didn't the stipulation actually, on balance, help your client in that it cut the legs out from under the prosecutor? The prosecutor made, I for one would agree, was a fairly egregious error, but then you had the stipulation which basically said the prosecutor's wrong. Remember when she made that argument about this? It's not true. Why didn't that help your client?
with respect, Justice Milkey, that's not what the jury was told, in effect, because the judge never told the jury they had to accept the stipulation as true. The judge told the jury, it's one thing for you to consider. And what the jury was left with was the Commonwealth speaking out of both sides of its mouth. On the one hand, the jury was told the Commonwealth is stipulating, and it's something for you to consider, that the defendant denied the allegations. And on the other hand, the jury is told by the prosecutor herself that, in effect, he did not deny the allegations. Why didn't he just deny the allegations when he had the chance? So the Commonwealth spoke out of both sides of its mouth. The jury was not told you have to accept this evidence, the stipulation. They were told twice by the trial judge, it's something for you to consider.
The judge instructs, ladies and gentlemen, I mentioned about stipulations, how you can treat these as evidence that the parties have agreed to. And the parties stipulate that the defendant denied ever touching the victim during his interview.
Justice Sachs, I think there's more to what he said. He said it's something for you to consider. Twice he says, it's something for you to consider.
Yeah, you can consider that the parties agree that he denied it. That doesn't mean you have to find him not guilty. Doesn't mean you have to find him guilty. But this is what the parties agreed to, this fact.
I think the language that it's something for you to consider is less than, and as I say, the parties agree is the Commonwealth speaking out of one side of its mouth, and on the other side of its mouth, it's saying in its closing argument with considerable opportunity for being persuasive that it didn't happen. So it's
at the time the defendant agreed to this, he didn't waive his objection to or claim for a mistrial, but he said this is the minimum that would be adequate, and he didn't say, no, this is going to prejudice the jury, this is going to be misleading or confusing to the jury. So at least I would be inclined to look and say, is there a substantial risk of miscarriage of justice from the reading of this stipulation?
I don't think that you can fairly say that defense counsel said this would be adequate. And you can't, if you're throwing up.
This is the minimum, and I don't object to it. That's what I'm saying. He said.
I'm sorry, I didn't hear you said.
This is the minimum that should be done, and I don't object to the stipulation.
Right. Well, you can't require a defendant.
In fact, it was the defendant's idea, defense counsel's idea.
The defendant wanted that evidence in at the evidence stage and wanted to be able to argue it. It was denied that. And you can't say to a defendant, if you want to keep this claim for a mistrial viable, you've got to turn down an opportunity for a crumb. Even though you're saying again and again, and the trial judge acknowledged, you're saying this is not an adequate remedy. And the trial judge specifically acknowledged that on page 101 of volume 4 of the transcript, also page 99. It's specifically acknowledged this is not an adequate remedy for this. But we're not going to turn down a crumb. We're going to ask for the loaf. But you can't ask us to turn down a crumb if it's being extended to preserve the request for the loaf. I don't think that would be at all fair. So because the Commonwealth spoke out of both sides of its mouth, and because the jury was never told this is established fact, you must accept it as true, the stipulation was not adequate to remedy the harm done, which the Commonwealth acknowledges was error. Twice they call it a misstep, once they call it inartful, but then on page 47, they acknowledge it was error. And it was an error of the type that I think is the third rail of closing arguments for prosecutors. And that doesn't even begin to touch, Justice Sachs, the point you made that there is a structural component to this. And
I wasn't making a point. I was alluding to your argument about the structural component.
Understood. But there's a constitutional component to closing arguments. And the Ortiz case cited by the Commonwealth, that was, the parties had agreed to a stipulation before the trial began about the fact that the cocaine was actually cocaine. There was nothing to be said in the closing argument by the defense in the Ortiz case about the fact that the cocaine was cocaine. It was just a timing matter of when do you tell the jury that there's a stipulation that cocaine is cocaine. It's a completely different matter here. This was exculpatory evidence the jury never heard, And the defendant never had an opportunity in closing argument, which is there's a constitutional dimension to closing argument, never had the opportunity to address.
Walk us through what the argument would have been had the stipulation come in earlier.
With respect, Justice Milkey, I don't think here at the oral argument on appeal I can recreate the closing argument, but that certainly would have been a component of a closing argument by the defendant that he denied it, to tell the jury that the words came out of the defendant's mouth, even though they didn't hear it from the witness stand from the defendant, that he denied these allegations. And the skill of a defense counsel is not adequately substituted, replaced by a dry stipulation, which I call the stepchild of evidence, read by the judge, which doesn't even tell them that they must accept it as true. So I think there's a reason why closing arguments is a critical part of a trial that can't be denied. And you don't look at, that's the point of a structural error. You don't look at, would there be something good that could have been said? If the closing argument was just, if a defense counsel was denied a closing argument, you don't look at what could the defense counsel have said that was persuasive.
Do you have any case that says that? I mean, why can't we say, usually with structural error, it's too difficult to evaluate prejudice. Here, we can say, all right, what would he have argued if he'd had the chance, and how much would that likely have swayed the jury? And you're essentially declining to speculate as to what he would have said, but it's not a very persuasive argument that it would have affected the jury.
I think it's too hard to evaluate what the prejudicial error was on the closing argument. Closing arguments are vital and they can be powerful.
We evaluate whether the Commonwealth's improper closing argument was prejudicial all the time. Why can't we argue whether a hypothetical defense closing argument would have been beneficial?
I'm not aware of a case where that analysis has been made about whether the closing argument could have been beneficial. I'm not. And I think evaluating prejudice is required when you're determining whether something bad happened. I think it's too hard at this point to evaluate whether something good could have happened. Before my time is done, I do want to touch on the two issues. The Martinkus issue, where the Commonwealth told defense counsel, I'm not going there, told the judge, I'm not going there, and then did go there. And that is the there being referencing the defendant's cousin's discomfort in leaving the house when she did, which twice the Commonwealth's brief says that Ms. Martinkus testified to that, and then says, but it was stricken. She didn't testify to it because it was stricken. It's not evidence. It's gone. It's wiped out. And yet, even though the trial prosecutor told defense counsel, I'm not going there, told the judge, I'm not going there.
You know, you on appeal, you make this argument that it contravened the prosecutor's prior assurance. I didn't see that argument being made to the judge. I saw the argument that it was unsupported by the evidence, but not that the prosecutor was contravening her prior assurance.
I believe that that's in my brief, Judge.
Oh, yes, it's in your brief, but I'm saying it wasn't raised below, or at least I couldn't find it being raised to the judge. So to the extent that's the attack on the argument, do we...
May I have leave to submit a letter alerting you to the transcript page where that happened? Because I can't cite it to you at this moment.
If there is a reference in the record, without argument, you can point to the transcript page.
Thank you, Your Honor. The other quick point is on burden shifting. I just don't see how the Commonwealth can claim that what this prosecutor said in closing argument twice, at the beginning, at the end, did not constitute burden shifting. She did not say, and it's a mischaracterization of my argument to say that it's improper to say, just look at the credible evidence. That's perfectly fine to say, discard the evidence that's not credible, look at the credible evidence. But she did not say, look at the credible evidence and determine whether it constitutes proof beyond a reasonable doubt. She did not say that. She said, look at the credible evidence and determine whether there's any other reasonable explanation other than guilt. That's a completely different standard. That's not even close to the moral certainty required by the reasonable doubt instruction. And to say...
Why did the judge's instructions cure that?
Because they were just the ordinary instructions given in every case. There was nothing specific to that objection given by the judge. It was just the regular arguments, closing arguments and not evidence, and the regular reasonable doubt. And there's case law about when there's a prejudicial statement made, such as in the Ramos case, which I cite, that the regular instructions are inadequate here. And that's what we're left with here. The jury was twice told that the burden is much lower than what it actually is, and that there is a obligation on the defendant to present a reasonable alternative other than guilt. And neither of those is true.
Thank you very much, counsel. We will hear from the Commonwealth.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. I guess I should start with the standard of review. The Commonwealth has acknowledged that these issues were preserved at trial, and we've been proceeding on the standard of review of prejudicial error, and acknowledge that my brother and co-trial counsel, when they were making the claim, making an objection and asking for a mistrial, and the subject of the stipulation was suggested, they said the stipulation's not enough, but then went forward with the stipulation to get, as my brother has phrased it, half a loaf. And I think their rights were preserved, and that's why I've gone forward on a prejudicial error standard. I'm sorry, go ahead.
On the wording of the stipulation, was there any discussion there or objection saying that it didn't go far enough because it didn't say the jury is bound by this?
I don't think the wording was disputed. I think the wording of it was agreed to, and just that any stipulation would be insufficient to cure what the prosecution had done in its closing is my understanding of the position of the defendant. And I've quoted the stipulation at page 38 of my brief so this court can review it. So I know I say misstep error. It's an error. The prosecutor acknowledged it was an error. This is, as I tried to explain in my brief, and as trial prosecutor tried to explain, she wasn't looking at it from that perspective. It's the kind of thing that when someone says, what are you saying, that it then comes clear, kind of unfortunate tunnel vision. And so she immediately tried to come up with solutions for having referenced the fact that the defendant, why didn't he just deny it, were her words. And he had just denied it, and the jury hadn't heard that he just denied it. He had also made a claim that he's not the only relative in the house, i.e. it could have been the victim's brother, Valerian, who wasn't even there the night of the knife incident. So, and that's what she was trying to get to. He's lying. So why did he bother to point to the nephew if he was so innocent in this? And that was the point of her argument. And then she said it in a manner that that stated non-evidence that the jury didn't hear. And then when it was called to her attention, first of all, there's an objection mid-trial, it's sustained, move on, and then afterwards they discuss it, and she's realizing what she has said, and she's trying to correct it. Maybe we can offer the police report, very apologetic. So this was not an intentional violation, as my brother suggests in its brief, even though this was a prepared argument and it was in writing, and she thought about it before she said it. She just didn't realize the import of it until it was received. And then when that was called to her attention, she tried to correct it. The judge does his instructions, they come up with the stipulation, the defendant's rights are preserved, and the stipulation goes right to the heart of the error. He did deny it on that day when he talked to the police in 2004. And so the jury has that as an agreement of the parties, despite the prosecutor's misstatement in her closing argument, though he doesn't discuss her closing argument.
I didn't see the actual written stipulation in the record. Did you include that?
I'm sorry?
The stipulation, the written stipulation that went to the jury.
Did not include that. I'm sorry, Your Honor. It didn't even occur to me to include that.
We're assuming it says what the judge instructed them, but
Yes.
but maybe if the parties could agree upon submitting that.
I would be happy to, if it's part of the record. And I also have no objection to my brother filing a 16L. He references, this is regarding the prosecution's promise on the Martinkus cousin issue. He references Record Appendix 36 of his record appendix, and it's a reference to the prosecutor's email when she's discussing the cousin, Donna Martinkus, that she said, I'm not looking to elicit the whole report or anything impermissible. That's the reference that he's saying, that the prosecutor promised not to elicit anything improper. So I have no problem with a 16L letter from him, and I have no problem trying to obtain the written stipulation for the court, or doing it jointly with my brother.
What cases are out there that you're aware of that address a problem in a Commonwealth closing argument by stipulation?
Okay, so my favorite case is Commonwealth versus Solanskis. Solanskis is a mid-closing objection. The judge goes a little further than in our case, saying, stay with the evidence. So there's an admonishment to the prosecutor. So that's a little different from us. Solanskis was, the defendant didn't present any records of the victim's psychological conditions. And the judge says, that's not enough, stay in the evidence. And then there's, like our case, there is a correction during the closing argument of, this is not proper, you didn't get that, the defendant has no burden, you're not going to consider that part of the evidence. And so it goes right to the point of the error and corrects it. And so what's said in Solanskis is the prosecutor was exactly wrong, did the wrong thing, and the judge could correct it. And he did so with an instruction. And so that's my favorite case on correcting, or the closest case on correcting the error of a prosecutor where it's referencing evidence that was not elicited. And in that case, the prosecutor had tried to, with a motion in limine, have it excluded, just like in this case. So I think Solanskis is right on point. But the manner in how you did it in Solanskis is an instruction, and the manner in how it's done in this case is a stipulation. So the closest case on that for the Commonwealth is Ortiz. My brother suggests that this is a constitutional issue of structural impact, and so nothing can be done on that. I would ask this court to look at Ortiz as I have done, and in Ortiz it says there was a pretrial agreement. It wasn't presented in the Commonwealth's case. The holding of Ortiz is if you're going to have a stipulation on an element, that has to be done in the Commonwealth's case in chief because of the burden of proof. So from now on, it's on the Commonwealth to make sure that your stipulations on elements are read before the close of the Commonwealth's case. This isn't an issue of constitutional dimension. And so I rely on Ortiz to say this is not a structural error. This is within the discretion of the judge to determine when it is appropriate to reopen the evidence for a stipulation. I've cited several other cases in my brief that permit the judge to do that. So this standard, while it's preserved, is an abuse of discretion standard. And here the judge had a big problem, yes, created by the Commonwealth, just like in Solanskis, and he did his best to get right to the heart of the problem and correct it, and he had the discretion to do so under Ortiz. And so I would ask this court to find that it's not reversible error in this case based on primarily Solanskis and Ortiz, but the other cases cited in my brief regarding a prosecutor overstepping in closing argument. It's Haraldstad and Harris and Heotz. And you can see in those cases where the bookends are, where the Commonwealth's error is corrected and where it is not. And I think in this case, because we're so close to Solanskis, that it falls within that. So I would...
Could we turn to the issue with the cousin? because it's a little troublesome that, I mean, I hear what you're saying in your brief about arguing that this is a reasonable inference, but in a situation where there was direct evidence of the discomfort, but that was struck, it seems to be asking the jury to think about the evidence that was struck. So there does seem to be some unfairness to that.
First of all, I'd like to apologize. And my brother said, you know, I refer to it as testimony and then note that it was stricken, and I was just trying to explain how the procedure of it. I wasn't trying to say that this was Martinka's statement on that was permissible evidence.
No, I
didn't
think
indicate
we
that.
all understood that.
So I apologize if that was misconstrued in my brief from what I meant. My understanding of the objection and the order, you know, striking it was that I was uncomfortable with how the victim was acting, so, you know, I got up and left. But I think her other testimony that she was there and left early, left quickly, a few minutes, I think is what she said. That's the evidence. I don't want to say I defend the statement completely. I feel like the statement is, I understand, it seems to be pushing to that point. Like, that's the part that the judge said you're not supposed to talk about, and here you are saying, and then she left early because of it, indicating she's uncomfortable, and that's the part that was stricken. So I understand what you're saying. The Commonwealth was referencing evidence that was in evidence. She was drawing an inference from it. The judge properly instructed on that it was stricken and what that means when evidence is stricken. And because this is a minor witness, it just corroborates that the victim was there one night and spent time in the defendant's bedroom with the door shut.
Just as a matter of fact, isn't it possible, especially given that this was a prepared closing argument, that the prosecutor simply forgot that evidence was stricken and was directly referencing, as opposed to thinking, oh, I can argue by reasonable inference?
I'm not sure that I can reach to she forgot about it, because she doesn't say that. She doesn't say that this is a preserved issue, so I don't think she said I forgot that was stricken or anything like that. So I don't want to misrepresent the record.
No,
I think she was just trying to say, like, this woman is there, something weird happens, she leaves a few minutes later, so she's leaving Bible study early. So I think she was trying to draw the reasonable inferences from the evidence, which she's permitted to do, and trying to garner all the evidence, all the permissible evidence for the jury so they can determine whether or not this victim was lying. And so I would say, in the face of how minor a character in this trial Martinkus and her testimony is, in regard to the very strong evidence of the victim with the knife incident, when she says she stays up all night with a knife, and then she gets up in the morning and rides to school, and the defendant's statement to the police corroborates that. He says he follows her to make sure she gets to school on time, but he knew she was uncomfortable. That's why he said he spent the night in the tent outside. And then she goes to school and she turns the knife into the principal, and the retired principal testified that she did indeed, and he knew he had the date and the time, 7:15 a.m. on such and such a date she turned in that knife. That's very strong corroborating evidence in a case such as this that doesn't have DNA, it doesn't have physical evidence, it's 10 years old because the victim didn't want to say who did this. So I would say the testimony of the principal and the defendant's statements to the police corroborating the knife incident, and the fact that the victim had given her first complaint weeks or a month before her parents even went on this New Hampshire trip, which is coinciding with the knife incident. It's very strong evidence, and so this Martinkus, the cousin, sees her one night at their house, and she's sitting in the defendant's bedroom with the door shut, is of minor corroboration when we have such very strong corroboration from the first complaint and the principal, and so I would suggest it is not prejudicial error.
Could I ask you about the motivation to lie evidence, or the excluded evidence? First of all, whether or not it was excluded, that the mother was seeking or upset with the defendant for money reasons. Can you tell me, first off, it doesn't appear there was ever excluded on the record. Was there an agreement that you're aware of? And second, whether it was actually the hearsay statements that were sought to be excluded or the actual evidence of motivation?
So on page 7 of my brief, in the statement of the case, I summarize the motion in limine. I could not find a ruling on the motion in limine in the record. However, when the prosecutor objected to the hearsay statement during the cross-examination of the police officer, that objection was sustained. So, so that could be the ruling on the motion in limine. In the motion in limine itself, she says the Commonwealth intends to elicit the defendant's statements that he thought the accusation may be motivated by the child's mother over money spent on fixing their mother's house, but seeks to exclude the alleged threat noted above. And that's at the defendant's record appendix at page 31. So I would suggest that the Commonwealth was not trying to exclude the financial motive of the mother, but the mother didn't testify, she didn't appear at trial, the defendant did not call her, and he did not ask the victim about any knowledge of the financial situation between the grandmother, the defendant, and her mother. And so without connecting it up, like you can see in Commonwealth versus Arana, the victims knew about the civil suit against Arana. But here, there's no connecting it up, so how can you bring in the fact that there's a hearsay statement about a financial interest? And so that's, I hope that answers your question. I would leave the rest of the issues to my brief unless there are further questions, and I would ask this court to affirm the defendant's convictions in this case.
Thank you very much. It's a very interesting case. It was extremely well argued by both sides. And if I could just address you, Attorney Lee, directly, you've argued in front of me many, many times. You've won some, you've lost some. Since this is presumably the last time you will be arguing in front of me, I just wanted to say it's always been a pleasure.
Thank you. It has been a pleasure as well. Thank you.
The case is submitted. We will take a brief mid-morning break before the next case, which is a DCF matter. We will be back in about 15 minutes.
Order, all rise, please. Court is now in recess.
Thank you all for your patience. We are back on the record. Our next case is a DCF matter. It is 2023 P664. You're all old pros, but I would just remind the parties that the case is impounded and to refer to the parties by their status. Counsel.
Let's see, I think it's still morning. Good morning. Laura Krismer for the mother. I want to begin today with the issue of subject matter jurisdiction. The question before you today is what happens when the home state doesn't understand or is not replying to the correct inquiry. The salient issue in subject matter jurisdiction, I just want to start, is over the child, not over the case. As the court is aware, what happened, we were scheduled...
Is that really what 209B says? I thought it was over disposition. I'm sorry, let me look at the addendum to your brief, but it's about a child custody determination. So it's about a claim.
Well, it's about custody over the child. I mean, in terms of looking at whether or not the court has subject matter jurisdiction, it has to do with an inquiry with regard to the child themselves. As the starting point. There was a remand order that came prior to our last scheduled oral argument, and we did receive 2 letters from a judge, excuse me, in the state of New York, Judge Polk. And I would suggest to the court that both of her responses were essentially non-responsive to the inquiry. In the first, she says, basically talking about personal jurisdiction over the mother and about the father's alleged failure to prosecute the paternity action in her case out of Schenectady County. In the second letter, she does make this statement that she declined jurisdiction over the case. And what I would suggest to the court is when she says over the case, she means over the case, the paternity action in her court in Schenectady County, New York, not over the care and protection case filed in Berkshire County.
Just to clarify 2 points.
Yes.
One, tell me if I'm wrong, but we don't have the father's complaint that he filed in Schenectady in the record. We do not.
And I would also suggest we don't also, I know DCF and the child have made reference that it was filed after the care and protection, but there is nothing in the record that suggests that, and I have scoured it looking for that. So I would just, we don't know. It was a paternity action that was filed in Schenectady at some time in 2018.
And the other point is, I take it you don't contest that the Berkshire County judge had jurisdiction to issue the emergency order.
Yes, under 209B, 2A3, it's a little bit like those law school questions that you have to do. 2A3, she had the ability to issue emergency orders. What I would suggest to the court, so yes, the initial temporary custody orders, we do not contest that. However, at that point, Section 3, I'm just going to call it Section 3, subsection 3, is only for temporary orders. In order to have any permanency orders, you have to have subject matter jurisdiction under one of the other provisions. And what I would, in terms of looking at that, the relevant one, and Judge McMenemy in her further findings of fact does reference this, which is 2A4. And under that provision, in addition to declining jurisdiction, the court in the other state has to do that because Massachusetts is the more appropriate, or the other state, Massachusetts, is the more appropriate forum, and it's in the best interest of the child. And again, we're looking at the period. We're not looking at now. We're looking at November or December of 2018. And at that period, Massachusetts was not the more appropriate forum. In fact, the record is replete with references by all of the parties, excuse me, that New York was the jurisdiction. The judge says things like, let's get this case back.
We understand that.
Yeah.
And you know, your briefing, including the post-briefing briefs, are all excellent. But let me just focus you on what was the Berkshire County judge supposed to do when there's not a pending removal action in New York?
I have a suggestion. As the court's aware, there are several Rule 23 cases on this issue. What I would suggest is that the court outline exactly what courts should do in using this case as an example. What I think the Berkshire County Court should have done, and there was some reference to this in the December 2018 proceeding, is that they should have contacted the court in the counties where the family was living at the time of removal, which was Kings and Queens County in New York, to file what the New York equivalent of a care and protection. That's what should have happened. There should have been a court-to-court referral, basically, of the case, at which point...
This is maybe a stupid question, but how can you do a court-to-court referral when there's no action in Kings County or Queens County or Montgomery County?
Or any county,
or
right.
Schenectady County,
Right.
or Rensselaer slips in for reasons that are unclear
You know
to me?
more counties in New York than I do. What I would suggest to the court is that there is an equivalent of the administrative office of the trial court in every state, but specifically in New York. It's called the New York Chief Administrative Judge. So what I think should happen is that there should be the Berkshire County, just to play it out in this case, the Berkshire County Juvenile Court contacts our administrative office of the trial court, says, I have this case, I don't have ongoing jurisdiction over this case, I need somebody from the state of New York, the New York Administrative Judge's office, and those parties then address that issue of exactly the sort of logistics in terms of how to do that. But certainly a transfer of the case to where the child had been living, which was...
But what does that mean, a transfer? Is there a mechanism where the case can be transferred, or is it really all about convincing the New York DSS to initiating?
Well, I certainly think that our DCF definitely could do that. There could have been, and I think there was some discussion about that.
And there's, I believe, evidence in the record that at least the King County DSS, I believe it's called, said the child has never spent a night in Kings County. We're not going to touch this.
Well, the child had, first of all, that's a misnomer, because the child had been living with her father at the time of removal in a homeless shelter in that county. So that's not accurate. She had lived there for several months with her father in the homeless shelter. And they were together at the time, and they were in different shelters. Father was in a family shelter, and mom was in a single adult shelter.
In Queens, right?
Yeah, in Queens. She was in Queens, and he was in Kings.
Is there anything in the record that explains why the father filed his action in Schenectady, where the family once lived but no longer lives?
Well, I believe that it was at the time, when they did live in Schenectady. They had moved to Kings and Queens County approximately, I believe it was a couple of months prior to the Thanksgiving holiday that started all of this.
You're saying that although DCF avers that this occurred after the petition in this case, that actually may be inaccurate. It's not just unsupported by the record, but inaccurate.
I would just, at this point, I would say, despite my best efforts, I haven't been able to locate it, and I don't know the answer to that question. I only know in terms of the purpose of it was really to establish paternity for the father. They were together at the time, and that was the purpose of it.
Where the Berkshire judge was made aware, and Berkshire judge is trying to figure out what to do.
Right.
And the judge is made aware of the pending action. You call it paternity, it's at least related to custody, the father's efforts to get custody from the mother. Was there anything unreasonable in the judge focusing then on Schenectady, since that was the pending New York case?
No, I don't think there was anything unreasonable. I think initially Judge McMenemy did exactly the right thing. She contacted the Schenectady County. She got a phone conference with Judge Polk, and the parties were all there. Where the error was the ball was just dropped in terms of any follow-up with regard to that. And everybody...
Well, the case was ultimately dismissed. What was the Berkshire judge supposed to do? The New York case.
Yeah, what I would suggest that she could have done is she could have directly contacted the authorities, the DCF equivalent in New York, or, as I'm suggesting, the administrative office of the trial courts, and
Well,
certainly...
the trial court in New York can't require DCF to file, or the
No.
New York DSS to file a case. There's this reference to a 1034 process, and
Yes.
and the Berkshire court can't order New York DSS to file a case.
No.
So, I mean, this certainly at least has the potential, if there's an outreach to another court in New York, for the case to kind of fall into limbo, where nobody's doing anything. The mother, incidentally, could have filed a case in New York.
I'm not sure what kind of case the mother would have filed in New York, but I would suggest that really the actor in this...
Seeking custody from the father?
I think that, well, first of all, it would have been after the care and protection proceeding.
Right, but then there would have been a court which had been told in New York, that had been told, or at least suggested, that it had jurisdiction to make a custody determination, and then there would have been something a little more concrete for the Berkshire judge to deal with.
I think, Your Honor, with respect, where it's DCF that is bringing the action, that the burden falls on DCF to perfect jurisdiction. And so what I would suggest to the court, that the onus was on DCF, and I think there was sort of like a telephone conversation, as best I can glean from the record. It was a telephone conversation, and I just don't think that was sufficient. I think somebody from the DCF office needed to say, hey, this has got to happen. Part of the confusion that I think we're under right now is that we do keep doing these Rule 23 cases, and that's why I'm suggesting to this court that a full opinion with mapping out some of these things is warranted.
May I ask, you talked about the options under Section 2. I was looking at Section 7, and specifically Section 7E of 209B, which says, if a court shall find that a court of another jurisdiction is or may be a more appropriate forum, and let's say it's the Berkshire court finding that maybe New York is a more appropriate forum, it may do one or more of the following, and then it's, dismiss the proceeding, vacate anything already entered, stay the proceeding upon condition that a proceeding be initiated in the other court.
Yes.
And then option 8 is enter any other order or judgment which may be meet and just under the circumstances of the case. Does that authorize the Berkshire court, if it thinks a New York court might have jurisdiction, but the only court that was suggested has now dismissed the only case that anyone knows of, does 8 authorize the Berkshire court to go ahead and finally adjudicate custody?
I would suggest that Section 7 that you just read authorizes what would have happened was a stay in the Berkshire Juvenile Court with the order, and I don't have that language in front of me, but you had indicated a stay with the direction.
Well, that's one of the options, but
Yeah.
but there
So
are 8 different things the Berkshire court can do, and the last one of them is enter any other order or judgment. It's a catch-all. Anything that may be meet and just under the circumstances. So
Except that the juvenile court in Berkshire County doesn't have subject matter jurisdiction. So that's the problem, is I think number 8 is assuming that they have jurisdiction. I would suggest that the stay with the transfer to the other court in here would be New York State. That's why, and I do agree that what Justice Milkey, what you indicated, it could be if it's just a fluke, really, that there was something pending. It could be any county in New York, which is why I'm suggesting the equivalent of the administrative office of the trial courts.
Are you saying that Section 7 applies only to a Massachusetts court with jurisdiction?
Yes.
And
under the emergency, I would suggest at the time, there was the emergency jurisdiction under 2A3. And at that moment in time, if we capture that, that's after the temporary custody hearing. If we capture that moment in time, that would have been the time for Judge McMenemy to then reach out to the New York courts under this stay provision.
can a court of more than one state simultaneously have jurisdiction?
I think it's very fact-specific inquiry. Off the top of my head, I would say no, because it has to do with where the child has lived.
So 7E says, if a court shall find that a court of another jurisdiction is or may be a more appropriate forum, the court here may nevertheless enter any other order or judgment which may be meet and just under the circumstances. So that suggests the Berkshire court could have said, all right, I think New York is or may be at least a more appropriate forum, but New York doesn't seem to be doing anything. I need to do something with this child. A temporary order will just consign the child to limbo, so I'm going to adjudicate this care and protection.
I would suggest that if that were true, that New York wasn't doing anything, that might be an option. I'm kind of working a little bit off the top of my head here, but that's not what happened certainly in this case. And I do think that it is the court that has to, at every part of the care and protection proceedings, the court has to make sure that they have jurisdiction, whether it is under, perhaps they might try to do it under the 7E provision.
Let me ask you this. You, in your briefing, you try to distinguish adoption of bill.
Yes.
Since it's unpublished, you are free to argue that adoption of bill is just wrong to the extent it blesses a nunc-pro-tunc curing of the problem.
Yes.
What's your position on that?
Well, I think the non-pro-tunc, I think that's essentially what Justice Shin tried to do with the remand in this case, was to get the non-pro-tunc. The problem is, in this case, all of the issues about the court having subject matter jurisdiction or not having it, and the fact that the parents living in New York really negatively impacted not just the parents, but the child. She lost her relationship with her parents. She has changed her position because she's lost her relationship with her parents. And so I think in terms of the non-pro-tunc, while it's easy for the courts and perhaps us on the appellate level to do that, in the practicalities of day-to-day life, it's not a very good solution. So I would suggest we not do that and that we do distinguish. I think in all of the unreported cases, I would suggest that all of the facts, the litigants at least had some relationship with the state of Massachusetts, whereas certainly mother had zero relationship with Massachusetts. Dad had some, I believe it was like 10 years prior, had some relationship with Massachusetts, but at the time of this proceeding had no relationship. And so I think that factually does distinguish all of the unreported cases. And I will rest on my brief as to the fitness arguments.
Hold on a sec first. Before we leave you, I just want to, the child has, from all appearances, a good placement now.
That's
and
correct.
appears to be thriving based on what is before us.
That's correct.
The pre-adoptive parent appears to be very open to continuing contact. Does your client understand that if this whole thing unravels because of the jurisdictional issues, it is theoretically possible that she may not end up with that situation?
Well, you're sort of asking me to go into a little bit of attorney-client relationship.
No, I really don't mean to.
No,
but
I know.
It's more rhetorical than.
The answer is, have I discussed this with my client? Yes, I have discussed it with my client. What I would suggest to the court, however, is that at the time that this action, I would direct you to how the foster mother described this child. When she came into custody, this child was a perfect, beautiful child, clean without any marks. The physician indicated that he had no concerns of anything.
Her caretaker was the father who is now dead.
Her caretaker was both of the parents. The parents had split into these two homes, these homeless shelters, in an effort to get a quicker spot on their, stable home. Both of the parents, and the record is very clear, mother spent a significant amount of time. They were just living in two separate shelters. They spent daytime when mom wasn't working. They did everything together at the time when the removal happened. Dad had simply gone to Massachusetts for the Thanksgiving holiday, and that's what I would suggest to this court.
The judge did not accept that. It may or may not be particularly important, but the judge found that it was going to be an indefinite stay.
But if you look at the record, that's an unsupported fact. I would rest on my brief in that. It's unsupported in the record. Thank you.
Thank you very much. We'll hear first from DCF, I believe.
Good morning, good morning, Your Honors. William Cuddle for the Department of Children and Families. We're going to be splitting our time, 8 minutes, 7 minutes with the child's attorney.
I suspect we're going to run over, but go ahead.
Judge Milkey, if I'm getting close to my time, can you please let me know?
Yes.
I just want to begin. I'm sure you're going to ask me questions about the jurisdiction issue. This case should not be decided on a technicality. Mother's counsel is ignoring a couple of important points here that I want to make sure that everyone's aware of, which is Judge McMenemy in our trial court and Judge Polk in New York resolved this issue. They first met in on December 21st, 2018, because this matter basically got dropped in Judge McMenemy's lap. They were trying to figure out exactly what to do. I direct your attention to read in Record Appendix Roman numeral 2, pages 102 to 125. Specifically, all the real relevant information is on 109 through 114.
But can we fall back a little bit?
Sure.
And start with some basics? It's my understanding that DCF is not challenging that New York was plainly the home state.
Correct.
That being the case, then there is no jurisdiction until the home state has declined or deferred, or I don't have the statute right in front of me, but the point is there has to be some kind of either action or inaction that says, okay, even though New York is the home state, we're going to let this happen in Massachusetts.
That happened in this case, Your Honor.
Well, did it?
Well,
because
it did.
Let me just.
Sure.
We understand what your arguments are, but let me just press you on the fact that the action, regardless of when it was filed, the action in Schenectady County was a private custody matter between father and mother that the judge, when they had the conference, the two-judge conference.
Yes.
I mean, both sides seem to try to paint it in a particular way. The reality seems fairly clear. The judge said, don't dismiss your action yet, but don't move forward on it. Let's see what happens at the upcoming hearing in my case.
I don't think she said, and
I'm paraphrasing.
Well, I think it's important when you paraphrase that that's where the rubber hits the road in this case, Judge, because Judge Polk didn't say, don't act on the case. She said, and I'll rely on the exact words, so she basically said, please maintain your process while we look into this. I'm not sure what New York State is going to do or is not going to do. Now, it's important there because Judge Polk is talking about New York State. Jurisdiction has to do with the state, not the venue. I don't want to get into the venue. It has to do with the state. And she was going to look into that matter because at the time, she knew there was, I don't know exactly what kind of motion was filed in Schenectady. I don't think anyone does. We don't have a copy of it, but the father brought some matter, and it was before that court because mother and father had lived there for 9 months before they left, for 2 months before the father came to Massachusetts, and they lived there after the fact during the case for over a year. So Judge McMenemy was left in a difficult situation. Looking back on it, it would have been better after the December 21st meeting for the courts to get together again, but I don't know the exact circumstances, but I can imagine.
Would that have mattered where the case in Schenectady County was dismissed, as we now know, because the father didn't serve the mother and the judge determined that there was a failure to prosecute? That seems...
That doesn't matter when it comes to
Counsel, if I may. That seems less than the kind of conscious effort contemplated by the statute for the two judges to get together and say, okay, where should this matter be heard? This is a case where even if the father was going to stay in Massachusetts for an indefinite period, there were virtually no contacts at that moment with Massachusetts, such that it didn't make a lot of sense to try this case in Massachusetts, except for the happenstance of where the child was at that moment. And no one is saying, oh, yes, it makes sense to have it tried in Massachusetts, even though New York is plainly the home state.
At the time, Judge, the court entered a temporary custody order because the child was without any care at the time. Mother refused to come to Massachusetts for the hearing. The trial judge was trying to do the best she could. We had respectfully speaking, the Massachusetts court had temporary jurisdiction over this case, and the New York judge asked the Massachusetts judge to maintain that while she tried to figure out what to do. The problem, what happened here, is that the New York judge didn't get back to Massachusetts in time to either accept the case or decline the case. But that was resolved, and it was resolved in December of 2023.
You're talking about the case.
The child custody case. That's what's before this court, not father's whatever motion he filed in the Schenectady case.
But isn't that the point, that the matter before the judge in Schenectady was a very limited action involving private parties? It had nothing to do with whether or not the child should be taken away.
But that's what brought the New York's court attention to the custody matter.
No,
And that's what's.
I understand that, but
I'm sorry, I don't mean to interrupt you, Judge. I very much respect you, but I want to make sure because these arguments I'm making, these are not in the department's brief, because this whole matter got resolved after the briefing schedule. December 12th, Judge Polk writes a letter, I know you have that, and Judge McMenemy has made supplemental findings, basically finding that New York declined jurisdiction over the case and that it's in the child's best interest for Massachusetts to continue its jurisdiction over this case. This child has been in the custody she's been in her placement, she's 5 years old. This case should not go back on a technicality when the matter's been resolved.
Now, Counsel, just in terms of the timing, there are 26 seconds left, but I will assure you we will go over.
Thank you.
But you keep calling it a technicality. We are discussing subject matter jurisdiction here.
Yes.
And neither side has gone into the cases in other states under the compact. There's a lot of, under the uniform statute, there's a lot of cases out there, and some of them are fairly strict on these issues. In terms of what should have happened here,
yes,
wasn't the point of entree the New York agency? I realize the declination has to come from a court.
Yes.
But shouldn't have what happened here would be that your agency contacted the New York agency, as I know some efforts were made, and said, here's the situation, you have to file a petition in New York State to remove the child, and then we'll defer to you.
I don't know if it was that simple, Your Honor. I mean, I think, to be clear, early on in the case, our department contacted Kings County. We didn't contact Queens County to my knowledge. Maybe we should have. But what you're asking me was spoken about by Judge Polk at that December 21st hearing. She basically said, if the case has to go to a different county, it can come to me and I can issue I think it's a 1034 petition or Rule 10, and whatever county it goes to, they can start an investigation. That's because she was talking on behalf of the entire state of New York. It didn't really matter which court had this case in New York. Judge Polk had it, and she handled it the best way she could.
Except in the end, what she did was dismiss it for failure to prosecute.
She dismissed, she dismissed the father's petition. The other reason in the record, the other reason that it went to Judge Polk, because mother had, I don't know the exact site, and I hope I'm not wrong when I say this, but there's evidence in the record that mother had previous custody proceedings, possibly in Schenectady County. That's why the matter was in Schenectady County. Everything, the parents had lived in Schenectady longer than any other place they had lived in the life of this case, as far as we all know.
Except, frankly, the record is very confusing in some respects, including some people at least attempt to conflate Amsterdam, which is in Montgomery County,
Yes.
with Schenectady, which is in Schenectady County, and Rensselaer, which
I don't know where
apparently has no
Rensselaer
tie
came
to
from.
this.
I don't know where Rensselaer came from, Your Honor. I understand what you're saying. It's
Can I
very
just
confusing.
ask for a factual clarification? You said a moment ago there was some indication that the mother had prior custody proceedings. Do you mean something before the father's petition that Judge Polk was aware of?
Saying earlier in the case, there's evidence that mother not related to this particular child. She was in a previous relationship with
Okay.
2 other children.
Okay.
And do you acknowledge that the father was in jail in Massachusetts for only 24 hours?
I saw that in the record. Yes.
So is it fair to say that the immediate emergency was over the next day?
Absolutely not. Absolutely not. Judge McMenemy had to consider what was before her. This father brought this child with no provisions, no plan to Massachusetts, and she was left high and dry. He had a history that we know about. I'm not going to belabor the point. The child was in serious need of help from the state. We're not talking about, I mean, it's an important point to keep in mind. We're talking about a 13-month-old child. The court did the best she could with what she had to deal with, and made extraordinary efforts to resolve it just a couple of months ago to clarify what the jurisdiction was. The child should not be punished in this case based on all the unfitness in the case. I'm not even going to get into it. You can rely on our brief and the findings that the court made. This child is where she's supposed to be, and there's no other result that would be fair in this case. Jurisdiction, given all of the circumstances, this is not clean. I acknowledge that.
Okay, counsel, we're way over, so I think we're going to
Right.
have to leave it
I'd
there and
ask
hear
you
from
to affirm the decree and rely on the department's brief. Thank you.
Thank you very much. We'll hear from the child's attorney.
Good morning, and may it please the court. My name is Laura Smyth on behalf of the appellee child.
Congratulations on your name change.
Thank you, Your Honor. I remembered to say it correctly. I'd first like to address for the panel these questions about subject matter jurisdiction that have come up. My argument to the court is that the Massachusetts court's conduct is in line with this court's unpublished decisions in Bill and in Kelsey. She contacted the court of a competent jurisdiction in New York, and New York had stated during that court-to-court communication on the record that it would like Massachusetts to continue with its case, and New York will decide if anything at all. The state of New York, she was speaking for the state of New York, will decide what we're going to do, if anything at all. I think the exact quote is, until we can actually determine whether New York State is going to do anything, if at all. Later, when this issue was brought up on appellate briefing, the trial court then sought the jurisdiction nunc pro tunc, which it received from the New York court when the New York court indicated that thereafter, implying after the dismissal of the case there in February 2019, I declined to exercise jurisdiction over this matter. And we know from the further findings by the trial court judge in our case that the case in New York was dismissed in February 2019. The decree terminating mother's parental rights in this case was not issued until March 2022. This court had jurisdiction to enter both temporary orders and permanent custody orders under 209B Section 2A3. The temporary custody part was met when the child was physically present in the Commonwealth and it was necessary in an emergency to protect the child from
And the
abuse.
mother is not questioning that.
Correct, Your Honor. The permanent custody was triggered by later in the statute, stating that the court may enter temporary orders or orders as it deems necessary unless the court of the other state has declined to exercise jurisdiction, has stayed its proceedings, or has otherwise deferred to the jurisdiction of a court of the Commonwealth. This judge would...
Put aside the nunc-pro-tunc efforts. Was that condition met at the time of the termination trial?
We would argue in our main brief, yes, that it was met when, during the court-to-court communication on the record in December 2018, that the New York court communicated, hey, we'll get back to you if we decide to exercise jurisdiction over this case.
I'm not sure that's a fair synopsis of what the court said. Everyone seems to have been in agreement that let's put this case on hold and see what happens. And then, for reasons that are not clear on the record, at least that I've seen, there was no communication. It just, termination trial went forward.
There was no court-to-court communication on the record that we know of after December 2018. However, in that 2018 conversation, New York says continue with your proceedings until the state of New York decides, if anything, what to do with this.
Now, at best, isn't the word continue ambiguous? It's saying, you know, continue and is often used as a verb to stay. And the judge, the intent here seems to be actually rather clear. They're saying, don't dismiss the action, but don't move forward with the action. Let's see what happens at the January 7th, I think it was, hearing. And that's the last we hear of jurisdiction until now.
So you were talking about paragraph 3, 209B 2A3. Unless the court of the other state has declined to exercise jurisdiction, has stayed its proceedings, or has otherwise deferred to the jurisdiction of a court of the Commonwealth. Which of those do you think applied here?
So at the time in December 2018, and in our main brief, we argue it's the otherwise deferred provision. However, when adoption of Bill and adoption of Kelsey were brought to my attention in the appellant's reply brief, and I read the cases and understood the opportunity we had to seek nunc-pro-tunc jurisdiction, we sought that. And the trial judge in this case obtained the nunc-pro-tunc jurisdiction. So I would say at this point, Your Honor, the other state has declined to exercise jurisdiction over this case, and Massachusetts, and they declined nunc-pro-tunc in past tense thereafter in her letter referring to when the case there was dismissed, which was dismissed in February 2019. So that allowed this court to enter permanent orders in 2022.
Do you have any published cases, I know you don't in Massachusetts, but in other states that you're aware of where jurisdiction was conferred nunc-pro-tunc?
I'm not aware of any published decisions. I know in adoption of Bill and adoption of Kelsey, they were the states of California and New York who were required to expressly decline jurisdiction. In adoption of Bill, this court remanded, well, it vacated the termination decree. Once this was resolved, nunc-pro-tunc jurisdiction, it came back up and this court affirmed the termination of the parental rights decree. So I would argue
unpublished.
It's an unpublished decision. Yes, Your Honor.
And have you looked for cases from other states under the Uniform Act about what otherwise deferred means?
No, I have not, Your Honor. If the panel would like me to research that and submit a letter to the court, I can do that.
I think we will confer among ourselves and decide what additional briefing, if any, is appropriate.
And I would ask the court if it is inclined to issue a published decision in this case, which I do think would be helpful to litigants and to practitioners and trial judges. I would ask that the court similar to care and protection of Manuel, issue its order affirming the decree to terminate parental rights and issue its opinion later. It's been over 2 years since this trial ended.
What if hypothetically we were inclined to do the opposite? Would you still like the order?
I would still ask that this court affirm the termination of parental rights decree to allow my client to be adopted.
No, and I'm not sure you understood the question. The question is, were we to conclude, and this is pure hypothetical because we have not resolved this, were we to conclude that there was a lack of jurisdiction here, would you still want the order first and the explanation later?
No. In that case, Your Honor, I would ask that the court, actually, I would like to know the court's decision as soon as possible in order for us to rectify it, and my client, who is now 6 years old from being 13 months old when this case began, to expeditiously resolve whatever matters. So, yes, I would like the court to issue the decision so we can continue with the case and move it along in my client's best interests.
Could you just react to what I was saying to Mr. Cuttle about the problem that the statute requires a judge to do something as the face of the home state, but the process appears to be driven by the agencies involved. And you can see, among other things, Judge Polk's frustration with the fact that he's trying to explain, no, we can't tell the agency what to do. So the judge in the home state is dependent to some extent on the agency, and the statute seems to almost presuppose that there is a court in which there's a pending action and the judges get together and they decide which form is more appropriate, which is very different from the situation here where I think objectively anybody would say New York was more appropriate here, but the New York agencies aren't doing anything, and there are incomplete efforts to get the New York agencies to do something, and none of this is to disparage the actions of DCF, who were presented with a problem here that they're trying to address. But this is, extremely frustrating case in terms of how all this played out, and unless my colleagues have any questions, I think we're going to have to leave it here.
I do have a response suggestion, Your Honor.
Sure, I'm sorry.
That the court in New York could have directed probation to file a care and protection, their version. That's likely what would have happened here in Massachusetts.
Are you aware of that? Because the judge seemed to be saying the opposite, Judge Polk.
Judge Polk could not direct their version of DCF to file a care and protection. And that's probably true. I don't know New York law enough to speak to that, but I would say in Massachusetts, what would likely happen if Massachusetts was faced with this dilemma, the judge would likely direct probation to file a care and protection, which it is entitled to do and does do. Sometimes with RCRA cases, they'll direct probation to file care and protection. So I would argue that that's what the New York court should have done.
And is there a name for such a petition?
It's a petition under Section 24.
I'm sorry?
It would be a petition under 119 Section 24.
You're assuming that New York has a similar, all right. And Judge Polk seemed to indicate that, no, New York does not work the same necessarily.
It may not have
like
the same
something about no emergency issue, she kept saying.
Yes, and I would agree. I don't know enough about New York state law to be able to speak to that, but there may be some mechanism, if not probation, another way that the New York court could have. And
well, if we were to ask for supplemental briefing, that might be something that would be worth knowing about.
It would be interesting to look into.
Thank you all very much. Let me just repeat the admonition, if I can call it that, I made to Mother's Council, which is the child seems to be in a good placement now. But there are some non-trivial jurisdictional issues, and there's not the strongest I'll just say this, there's not the strongest evidence in the record that the mother is ready and prepared to assume custody. So if there is not, if we were to conclude there's not jurisdiction here, this could be a long, drawn-out matter that benefits no one. We will do our job in terms of addressing the issues that have been placed before us, but this is one of the rare DCF cases where it might make sense for the parties to consider their options in terms of open adoption agreements or what have you, in terms of resolving this outside of our purview. So I will leave you with that thought, but I assure you that we will do our part. So thank you all very much. Very interesting matter. The case is submitted. The next case is 2022 P1182, and it is a divorce-related matter that has been impounded. It's frankly not entirely clear to me why the whole case is impounded, but for the moment at least, if the parties could refer to themselves by husband and wife, or if you will, ex-husband and wife.
May I begin?
Yes.
Good morning. If it pleases the court, I am Christine DeBernardis, and I represent the husband in this particular case. If the panel has no particular direction where to begin, I would begin with argument number 3. That concerns the life insurance policy. And so, as the court's aware, the wife had a 20-year convertible life insurance policy in this case. Originally, it was held in a trust, with the beneficiaries being both the husband and the wife. At trial, it was held in, it had been transferred to the wife's private trust, where the beneficiaries were the children and the trustees were the wife and her son. What evidence did the court have before it on this particular life insurance policy? Well, there was the policy itself, there was the valuation by Mr. Staffier, and there was testimony from husband, which said that there was a market for sale for this policy. And an important point there is that in the court's findings, the trial judge credited that particular testimony by husband.
Well, I'm not so sure about that. The trial judge said, well, I assume there's a market. And the judge, the husband said, yes, I've been in touch with companies that are interested in buying policies from people with MS. And wasn't allowed to go further, and clearly there was hearsay lurking there or embedded in that statement. So, but the judge did assume that there was a market. Then the judge went on to find there is no, the policy has no independent value, which was a change from what the wife proposed in her finding. The judge added the word independent. What did the judge mean by independent value, in your view? To the extent you can read his mind.
To the extent, I'm sorry.
You can read his mind.
I can't read Judge Anderson's mind ever. I think, honestly, I think the court was trying to indicate that as a term policy, the value at the time of trial, in his opinion, was 0. But I think that conclusion, obviously, with the argument in my brief, is incorrect. There's, Mr. Staffier established a value, and that value wasn't, the number itself wasn't challenged in any way, shape, or form. But even if that number was wrong, he established that at the time of trial, there was a value. And indeed, that value was not 0. I think, and I've heard judges say this, and I've heard Judge Anderson say, to establish what the value is, the best way to do that is to put the item on the market. So I think easily, as I've suggested in my brief, Judge Anderson could have ordered this to be placed on the market and sold, and then we know the value.
Your brief says noteworthy is that there was no order by the trial judge that the policy be maintained post-divorce for the benefit of the children. If there were such an order in the judgment, would that support it being either excluded from the marital estate or being valued at zero, depending on how you phrase it?
I don't think so, no, but I do think that it's interesting that I don't feel it's relevant that the policy was meant for the benefit of the children, but I found it interesting that the court mentioned that, yet didn't make sure that the policy was secured for the children.
So is the suggestion that the wife could change the beneficiaries and then sell the policy somehow?
Well, she certainly could, right? Because there's no mandate that she doesn't. So I think certainly this policy that has some value, and arguably has a value today as well, though that value may be different, can be converted by wife if she chooses to do so.
So hypothetically, if this were the only error that we found in the judgment, that the judge gave it zero value yet recognized or assumed that there was a market for it, if we had to remand for the judge to either stick with one or the other of those findings or make a determination, would we, if the judge were to find that it did have some value and decide what that value was, would the judge have to reopen any of the other property division? Or could the judge simply say, all right, I've decided based on whatever evidence that it's worth X today, $100,000, $20,000, whatever, and then the judge could divide that value as appropriate, assuming, again, that we had affirmed the rest of the judge's rationale?
Potentially, I think the other evidence does have to be opened. And the reason why I say that is because when the judge was deciding...
Evidence or division?
Division, I apologize. Okay. I do think the division could possibly be affected, and I think it has to do with a few things. Number one, there was no definitive number that the judge used. He didn't use 60-40, 70-30. So I think it would be difficult to say how, if there was now a value to this policy, it would be divided. But second,
isn't that up to the judge in the first instance?
Well, I think it's up to the judge in the first instance, but he appears to divide all of the assets in a way that isn't comported with a particular number. And so I think if we're now just dividing this one separate asset, it comes into the whole. And I think
but couldn't the judge say, given how I've already divided the other assets, and now that I'm finding the policy has X value, I'm dividing it as follows, and here's why. And here's why it's consistent with what I did before.
I suppose he could, but I do think if you're talking about an $864,000 policy, let's say he values it at that changes the landscape of the rationale, because now these folks have a remarkable, that's almost another $1 million, right? So that's a difference in the estate that I think is important enough, it's certainly not nominal, that the rationale should be, the division rather, should be revisited. If he values it at $20,000, maybe not. But I think if he values it at the higher end and anywhere near Mr. Staffier valued it, that the division really should be revisited. And I think just one other thing I would say about this, when I think about this asset, I compare it to, I think about comparing it to other assets in the division. So if we had a house and the house was in a trust and it was meant for the children, would we shelter that for the children in a division on divorce, or would we divide that between the parties? I don't see how this is any different.
Presumably the husband, the former husband, could agree with the former wife that this policy should be maintained for the benefit of the children. I'm not suggesting that he did so, yes, but he could, and they could divide the value of, the hypothetical value of it however they wanted. Or exclude it from the estate, saying this is something she's purchased, she's continuing to pay for, it'll benefit the kids. As long as that's locked in, we're not going to use it to disturb the value of the, or disturb the distribution.
Yeah. Okay. Presumably, yeah, they could have stipulated to that, but it was argued as an asset.
And they still could?
Yes, they could.
Okay.
Yeah. Moving on to other arguments, I'm sure that the panel recognized, because I think it's stated several times in the rationale and the findings, that the trial judge felt the husband's behavior and his activities outside the marriage both hurt the marriage financially and hurt the wife emotionally, damaging his relationship with his children and his wife. I saw words like destroyed relationship with wife and children, emotionally impacted by the husband's betrayal. The wife, on the other hand, is someone who has deteriorating health and has no ability to support herself in accord, or rather, as characterized by the trial judge. But the wife was not seen in a way where any of her actions were deemed negative or improper when you look at the rationale overall. And I think that that is the overreaching theme within the case as characterized by the trial judge, but also brings me to arguments 1, 2, and 4. Argument number 1 is the argument that talks about the judge's findings of facts.
Can I ask you a particular question about the rationale, just before we get away from that?
Yes.
Which was, and you've argued in your brief that there wasn't adequate weight given to the whether the wife took appropriate steps to reduce her liabilities, her future liabilities. And you quote the husband's testimony as saying she should have, we had a plan that she was going to apply for Social Security disability, get Medicare, get Mass Health, create a trust, and she would need $250,000 to cover her for 5 years. Is there any evidence that the wife ever agreed to such a plan? Did the judge have to accept that as something the parties had thought was feasible?
I don't believe that there was an agreement in wife's testimony that she accepted that plan. But another thing that touched on that issue and wife's ability to support herself was the idea raised by the trial judge during the testimony that wife could defray her exorbitant care costs by applying for Mass Health. And he even inquires, kind of stops testimony during the trial and says, hasn't wife applied for Mass Health at this point? Because you really should be doing that.
I saw that, but is there anything in the record from which we could conclude that that was feasible, that when she would have been eligible, and what that benefit would have been and what that would have done to the property division? Because it's presented in the papers as kind of an abstract possibility, but we don't know what impact it would have had on the wife's needs and at what time in the future.
I don't believe there's any evidence in the record that would have given an idea of what the benefit financially, or a number of what the benefit would be, no. So with respect to argument number 1, this is the argument that talks about the fact that the judge's findings were substantially copied or adopted from the wife's proposed findings. And there are numbers in the brief that show you that hundreds and hundreds, over 400 of wife's findings, wife's sentences, were incorporated into the judge's findings of fact. We talk about whether or not that indicates to this court that there was an independent analysis of the evidence. And we talk about the idea in the case law of the badge of personal analysis. And so that talks about, with respect to the badge of personal analysis, was there enough difference in the findings that would show us that this judge made an independent analysis? I argue in my brief that that is not the case. But the bigger issue, I think, is that wife's proposed findings were not always accurate. And there were proposed findings that were not accurate that were then adopted by the court. And the harm there is that now the court is using misinformation to make decisions on this case and to decide what the division of assets is.
Which do you think was the most material of those, what you term the mistaken adoptions of the wife's findings?
That, I think, is a hard one, because there were many that led to large amounts of sums that I think were not accounted for.
Give us an example.
Guess, huh?
Give us your best example.
My best example. I guess I would say the money from mother's estate. It was valued when it came into the account at $684,390. In wife's findings.
She says that the trust was created after.
Yes.
And in fact, the trust was created some months earlier.
Yes.
Okay. How did that affect the property division?
Well, we're talking about credibility, and we're talking about the judge's view of the parties.
Well, the mother didn't testify that it was created after. It appears to have perhaps been a mischaracterization or misunderstanding in the wife's proposed findings. But the mother didn't say, oh, you know, after the checks were received, I created this trust. She agreed that it was created in February with Myrick O'Connell. So I'm not sure how it bears on mother's credibility.
Well, I understand that that might be the case, but the judge made his decisions based upon the fact that it happened the way mother said in her proposed findings. So where the judge got it wrong, the judge has the wrong information in his head. So maybe it's not credibility, but again, that whole overall theme of wife did nothing wrong and husband did all of these wrong things.
Well, why was it wrong to create a trust in February to try to protect some assets, given what the wife knew about the husband's dissipation of them?
It was set forth as a situation where the monies came in and wife then sheltered them. But if you really look at the timeline, it's more that wife was making phone calls to her attorneys,
She was making plans.
She was making plans.
But how does that affect either fault or the numbers used in the final property division? It's not as if she grabbed that $600,000 and then went off and spent it on something that she didn't need, that nobody needed, that wasn't for the family, that she dissipated it. And she was spending it on long-term care, or her placement, and family expenses, attorneys.
Yeah. And so all of those are permissible expenses, but they do fall on mother's side of the fence when we're talking about division.
Yeah, but did the judge conclude otherwise?
Well, the judge did conclude otherwise because he found that there was only $382,000 that mother spent over and above, rather, wife spent over and above husband. And not $684,000.
But she didn't spend it. She didn't spend it all.
At the time of trial, that account was zero, according to the record and the financials.
Well, I didn't see that in the briefs. So you're suggesting that the wife dissipated $600,000?
I don't know if dissipated is the right word.
Let me ask you, how much did she dissipate? You're saying some of it was permissible, but you're suggesting that the account was drained. So where did the rest of it go?
For sure, and I think that she's allowed to use that money, but I do think that when the court went through the findings, the court said, husband used this, husband used that, wife used this, wife used that. We didn't see these monies accounted for in that particular rationale. So when I think of the word dissipated, the word presents a negative connotation to me as if she shouldn't have used it for that. The automatic restraining order does not prevent her from using it for her care, for her attorney's fees, et cetera, but it should be charged to her side of the V when the judge does the division. And that's where I don't think this happened.
Are there any clearly erroneous findings with regard to the wife's needs?
I don't think so. Not that I can immediately recall.
Why isn't this particular division of property supported by those undisputed findings, separate from any bad acts from either party?
Can you say that again? I'm sorry.
Why couldn't the decree here be supported by the undisputed difference in the wife's needs versus the husband, quite apart from any fault on the...
Do you mean by that fact alone?
Yeah. Coupled perhaps with the undisputed facts about the husband's bad behavior.
But if we have to bring that in, don't we bring in the what we would call bad behavior of the wife during the pendency of the divorce?
Not all bad behavior is created equal.
I don't disagree, but I think if we talk about all of the bad behavior of one party and really don't acknowledge the other behavior of a party, I understand it may not be equal, but if you look at it, it really wasn't considered at all. Wife's actions, misusing the power of attorney, and all of the things within the brief were almost justified by the trial judge. And I think that goes back to the characterization that I set forth to the court. Husband did a lot of bad things. Wife wasn't held to the fire, and I think that's just incumbent in the division and in the findings. But there were things that should have been mentioned.
I think we're going to have to leave it there. Thank you
Understood.
very much.
Thank you.
We will hear from the wife.
May I begin?
Yes.
Good morning, members of the panel. May it please the court. My name is Amanda Vanderhorst. I am here representing the appellee, the former wife. This court should uphold the lower court, Justice Anderson's, thoughtful and comprehensive decision and deny the former husband's appeal as frivolous and nothing but the former husband's continued attempt to justify his conduct, attempt to shift blame and responsibility from himself to the wife, to the children, to the court, and in his brief and testimony, now to the Commonwealth of Massachusetts and the federal government.
While you mentioned that word, it reminded me, I wanted to ask, what's the basis for the fee request in your brief?
That this appeal is frivolous, that this is a thoughtful...
No, but statute, rule, what's this authority for the...
I apologize, Your Honor, that I do not have the statute or rule in front of me. I would be happy to file a supplemental brief on that request.
Maybe you could turn first to the life insurance policy issues, and I guess my first question is, do you know, or do you think you know what the judge meant when he said it has no independent value?
Yes, I do. If you give me just one moment, Your Honor. So in terms of the independent value, it is my opinion that the judge, in adding that to my proposed finding, was finding that there is no independent, separate value apart from the potential value that the children will receive as the beneficiaries of that policy when the wife passes away, if that policy is still in effect at that time. Because he did make extensive findings regarding the length of the term policy, that the term terminated as of 2027 and would be financially difficult to maintain past that date, and there was a potential that it wouldn't be maintained past that date. In the trial court, term life insurance policies, I will be completely frank, I have never seen a value assigned to a term life insurance policy.
Okay. So there was clearly testimony that there was a value. The judge allowed it in, and it was $845,000. The judge says he assumes there's a market, and then he says the policy has no value. How do we reconcile those two findings?
I believe that what the judge did in allowing Mr. Staffier to testify is he allowed...
Try to avoid names, please.
Pardon me. When he allowed the expert, alleged expert, I would say, to testify, he allowed his testimony to come in, but he was not required to afford any weight to that testimony.
Right. That's true, but he didn't say I'm not affording any weight to it. I'm saying I'm assuming there's a market, yet it has no value. How can those... A market means there's someone who's willing to buy it.
I think the same could be said of an heirloom item, Your Honor, that if there was an heirloom item that was held by one of the parties, they could assume that there is a market for it, that there is a value to it, but that there could be testimony that it is the intention to pass on the grandmother's ring to subsequent generations, and it did not have to apply a value to it in the division.
Well, if the husband had agreed that this policy should be maintained for the benefit of the children, that would be one thing. But he didn't agree. It's not an order. It doesn't seem theoretically impossible that the wife could change the beneficiaries and then somehow convert this policy to a liquid asset.
And to speak to that...
Take a loan against it.
And to speak to the question of the agreement, because Your Honor asked my sister as well, that was a possibility. The wife was more than willing to agree to that. The husband refused to that because the husband, throughout this case, has been simply looking to obtain more funds for himself, arguing, as he did in the Medicare and Medicaid and Mass Health argument, that the wife should not have the benefit of this marital estate despite her incredible needs, and that instead he should have access and be able to have all of these funds because, from his opinion, he earned it all and he gets it. That was his overarching message throughout this case.
So I'm going to ask you the same hypothetical question I asked Father's counsel. Hypothetically, if this failure to assign a value to something for which the judge assumed there was a market was the only error that we found, and we were to remand for the judge to reconcile those two findings, determine a value if he thinks the evidence is there is a value, then would we need to allow him to reopen any other parts of the property division, or could he simply distribute the value of this equitably in accordance with the prior rationale?
I disagree with my sister, and I do believe that if Your Honors were to remand it on this issue alone, there would be no reason to reopen the remaining property division, and that the court would have the ability to determine what, if any, value he thought that this policy had, and then determine the equitable division of it, which could very well be 100% to the wife or divided up in another methodology. But I do think that this term life insurance policy was properly held, as Justice Gantz noted in the brief that in the case that I cited in my brief, that term life insurance policies are not assets since they have no cash surrender value during the life of the policyholder.
But they're different. They may not be, well, whether or not they're assets, I mean, the definition of asset is pretty broad, or the definition of marital property is pretty broad.
Yes.
If it can be sold for value, then isn't it an asset?
I do
Couldn't
not.
it be considered in the division?
I don't think that anything that could be sold for value is automatically an asset that is required to be sold for that value. I think a term life insurance policy is a different category in that it is a contract. It is a contract that has a conditional interest subject to defeasance until the death of the insured.
Right, so whether it will pay anything is quite speculative, but there are a lot of speculators out there who will buy speculative assets.
I don't think that requires it to be marketed and sold in order to be able to maximize the cash that is available for the division. I think that the term life insurance policy has a different purpose and principle and a different treatment in the probate and family court, which is appropriate, which is to ensure an obligation in the event of a death. Oftentimes when life insurance policies are ordered in the probate and family court, it is to ensure an alimony obligation or a child support obligation, not to.
Okay, but isn't that usually a policy that final judgment orders one of the parties to obtain in order to ensure an ongoing obligation?
Or oftentimes to maintain. And the court in this order did not order either party to maintain life insurance for the benefit of the other. And
So if it's ordered to be maintained, then it's for the benefit. Well, I guess I'm struggling with the idea that ordering it to be maintained means it's not an asset. It has to be valued.
No, in terms of the court specifically said that there was no order to maintain either party to have a life insurance obligation because there is not the ongoing obligation, which is typically why a life insurance policy is ordered to be maintained in a judgment. I've noticed that I only have about 7 minutes. Is there a particular argument that I should focus on or continue?
I did have one particular question about the sale of the house.
Yes.
It was sold for $1.75 million, which apparently was $700,000 below what the town had assessed, or as it's stated in one place in the record, appraised the house at, $2.47 million. Is there an explanation of why that was done and how the judge found that it was sold for fair market value?
Yes, Your Honor. So the house that was listed, it was at a higher appraisal value, and in fact, in the first financial statement, I listed the appraised value as typically do. When there was
Appraised or assessed?
Pardon me, assessed.
Okay.
When the wife engaged a real estate expert, or pardon me, engaged the realtor advised that she did not think, given the market at that time, that the house would sell anywhere near that. In discovery, we also received that the husband himself did not believe that the house was valued was appropriately assessed at that value. He had actually filed for an abatement.
Are those cited in the brief?
They are not cited in the brief, but they were exhibits at trial.
You know what exhibits?
I do not know the abatement off the top of my head, but I could provide it in terms of the exhibit that it was.
It's a little difficult to fight through the record and find the evidence about whether this was actually fair market value or whether there was a $700,000 loss because of the timing.
And, Your Honor, that's part of the testimony that was given and the records that was submitted, is that the husband himself filed for the abatement stating that the assessed value was over the value that it should have been. He also, when he did his submission to the federal government in connection with his criminal case, he listed it as at a value of less than the assessed value. And the court appointed a special master, Michael Ring, who has unfortunately passed, to be the special master to determine if the value was appropriate and that it was sold at the right amount. Further, not only did she appoint a special master, because at that point in time it was Justice Burchill rather than Justice Anderson, there were 3 judges on this case, but she permitted the husband to do a walkthrough of the house with a realtor and to provide an opinion of value. The husband did the walkthrough. I was present for that walkthrough for an hour. And then at the next hearing, he did not provide any opinion of value given by that realtor. Instead, he provided his own calculations and his own justifications, as is a pattern throughout this case, to try to justify the value that he thought was appropriate.
Did the timing had something to do with COVID? I mean, you say that there's evidence that the wife was told by a realtor that the assessment was too high.
No, this was before COVID. This was right before COVID. Because the wife moved out of the home in the fall of 2019. The house was sold in 2019. And initially, the opinion was that it was a very good thing that it had been sold and had been marketed because it had not been anticipated that there would be the COVID bump of the real estate market, which occurred thereafter. But I do think that the special master, as a neutral and had the ability to assess that. The husband had more than enough opportunity to argue before the house was sold, and that argument was dismissed by the court appropriately because it was not based upon anything other than the husband's wishes. Is there another particular argument? I have each of them.
Whichever you think is the argument you'd like to make.
Thank you. Well, in totality, given that I have only 3 minutes left, this was an extensive case. The court took 9 days of testimony and issued extensive findings in this case. He went through a thoughtful analysis. Not only did he consider one scenario and base that scenario, but he considered multiple different scenarios. In his rationale, he goes through 4 different scenarios of how to arrive at the division of assets and ultimately determined this, and his only hesitation was that it was not more for the wife. I argued in the proposed findings and throughout this case that the wife should receive what is left of the marital estate because the husband had already dissipated a significant amount through his conduct and through his intransigence in the legal process, which he continues to do today. The wife has significant needs that have increased since this case. She has continued expenses for her assisted living, and all she has is what remains of this marital estate. She does not have the ability to continue to pay legal fees for me to continue to argue this and fight this. And she did not have the ability, and I would argue that significant legal fees were wasted in having to litigate this case in the first place. This matter is about a husband who cannot admit wrongful conduct and the effect that it had on the wife, on the marital estate, and on the family.
The judge said that he appeared contrite.
He appeared contrite, and then he files this brief, which instead of being contrite and recognizing his wrongdoing, is instead trying to blame the wife and trying to say that the court did not blame the wife enough and that he should get more money, his children should not get his life insurance, his wife's life insurance policy, and that instead he should have to incur more fees and she should have to incur more fees so that he could try to get more away from her when she already has a significant need for her care to be able to continue on. He also tries to blame the children. He alleges in his brief that these children are autistic and cerebral palsy. These children are doing excellent. There is no evidence of that, as we tried to address. That one child is at MIT currently, another one is getting a dual degree at Harvard, and the other one is working in finance in New York City. These are successful children, but instead the husband, as he did to the wife, tries to say that he is the martyr and that he has this horrible situation, and therefore the court should have compassion for him and see how he has been wronged. The only person who has done wrongdoing in this case has been the husband.
Can I ask you one particular additional question before you finish, which is related to what I asked husband's counsel? The husband suggested in his testimony that there was some plan to apply for Social Security disability, Medicare, Mass Health, create an irrevocable trust, make it through 5 years, and then the wife would be all set.
There was no such plan. That was the husband's decision and desire to try to exploit the process and exploit the wife and try to keep marital assets away from her and instead have the Commonwealth of Massachusetts and the federal government responsible for her care rather than the marital estate.
Thank you very much. We'll have to leave it there. The case is submitted.
Thank you.
Our next and final case of the morning is a SORB matter, 2022 P691. It is SORB number 97354 versus Sex Offender Registry Board.
Good afternoon, I guess, at this point. My name is Elizabeth Doherty. I represent the petitioner in this case. May it please the court. In this case, this is a case in which the board failed to meet its burden to show that the petitioner in this case, an individual who committed his governing offense at 19 years old, and now 16 years later, after living lawfully, stably, and safely in the community, that the board is continuing to state that it's still appropriate for him to register. I would submit that the board's decision was deficient in a number of ways, and the hearing examiner's decision relied in large part, in most part, on hypothetical and speculative potentialities, things that...
Isn't the whole scheme based on that? I mean, whenever in an ordinary classification case, it's all about trying to figure out, you know, what category the person's in, and it's all based on prediction.
Well, that is true. The entire process, of course, is a predictive kind of thing, and you're looking into the future as to what may happen. But the SORB jurisprudence is very clear that risk and danger have to be based on cognizable, knowable, perceptible facts. And in this case, frankly, it appears that the hearing examiner's determination that this individual continued to present a risk and danger, despite, as I say, living in the community safely and law-abidingly for more than 10 years, 16 years, was based on things that she imagined might happen. The crux of her decision appears to be that she was basing his continued risk on demonstrated lapse of judgment and boundary issues. The fact that...
But, I mean, historically, your client plainly had demonstrated boundary issues. He may have been young, there may be mitigating factors, but it's not crazy to be concerned about his having boundary issues.
Well, I would submit that the mandate of SORB, its legislative mandate, is not to guard against poor judgment or boundary issues. Its mandate is to guard against sexual recidivism, which in this case, there's no demonstrable fact that is predictive of that.
Well, we have all of the factors that were considered in the original classification, where he was level 2, and then he was reduced to level 1. But are you saying that those factors just drop out and are entitled to no weight in determining whether he still poses any risk after a certain amount of time?
No, I'm not. But this case now presents some question as to some of whether those factors are still applicable. Now, certainly factor 2.
Before we get there, can I just probe on that? Are you saying that as a matter of fact or as a matter of law? Because speaking only for myself, I'm a little confused by what precisely you're arguing on the law about how the standard is different for this kind of proceeding than it is for an ordinary classification proceeding.
Well, this is a term, he moved.
No, I understand.
Okay. Well, then I guess I'm not sure that I entirely understand your question, Brett.
Well, in an ordinary classification system, we have the factors, we have the facts. The hearing officer looks at the factors as applied to the facts, and one way or another comes out with an answer in terms of what risk category. This is a somewhat different proceeding, but it's not clear to me why you wouldn't still look to the same factors. And you started to say, oh, some of the factors don't apply, and I was saying, is that a matter of fact or is it a matter of law? And to the extent this is a different proceeding, a deregistration, whatever you want to call it.
Termination, yeah.
Termination. What are the legal considerations, and why don't the factors still apply?
Well, I think that in responding to that, I guess I would respond to Justice Stack's question first as to which factors I would submit don't apply, and I would submit that our court's now recognition of the incomplete neurobiological development and the brain plasticity, which contributes to a great change, would suggest that factor 2, I would have to acknowledge, would continue to apply, but factor 3 would likely not apply in that
Okay, but let's look at factor 2. And I made something of a career on factor 2, for good and for bad. If factor 2 applies, and it appears to apply, why isn't that enough to constitute substantial evidence that he presents enough of a risk that you're not going to terminate his registration?
Well, and I think this is where the decision of the hearing examiner, and this goes to law, and now I'm sort of depending on, and I do hate SORB cases because I have a hard time remembering numbers rather than names, but I do remember this number. It's Doe 24-341. So yes, the factors can be considered, but in this case, the hearing examiner gave no indication as to the predictive value of that, the predictive value of his offense, why those factors applied. She did relate them to what the circumstances why they would apply, but no indication as to why 16 years later, when there's been no facts in between, no post-dating the offense to indicate a risk, why that factor 2 would still be determinative. Why
Is this any different from an ordinary classification proceeding in that once the offender brings forward
a burden of
production, changed circumstances, then it's up to the board to prove by clear and convincing evidence that the person still poses a risk?
Well,
so the board, do we agree on that?
Well, I think it is different because it is a termination, and again, I did remember this. I'm looking at Doe 76-819, where they recognize that this passage of time, this 10 years that's in there, is to be taken into consideration. And they even contrast that between like a reclassification situation where you have 3 years have gone by, but at this point, 10 years, and in this.
So you're referring to 178 K2D, the 10 years before you can seek relief from registration?
Well, I'm referring to the discussion of it in that particular case.
The legislature didn't say offenders must be relieved after 10 years. They
No,
said
they-
offenders must be relieved after 20 years with certain offenses,
Right.
which would actually include what is defined as a sexually violent offense, which includes indecent assault and battery on a child.
Certainly,
But
that's...
the legislature doesn't say those factors are not worth anything after 10 years.
Absolutely.
So is the board required, other than its time offense-free in the community factor, 29, I think it is the board required to say after 10 years or after whatever period of time, factor 2 is no longer entitled to any weight?
No, I don't think so, and I certainly wouldn't say that. But they can't just depend on that particular, on that factor.
Why?
Because there, especially in the whole Doe 24-341, where they talk about all of the things that have to be considered. If that were the case, then I'm not sure how any person that were living a law-abiding life for that period of time, if the factor continues to be dispositive, then...
Well, of course, they have to consider all the factors for which there's, that the facts suggest might be applicable.
And I would submit in this case they did not. They did not consider those factors.
Which ones weren't considered?
They did not consider the fact that they did not meet their burden in that they did not identify facts that postdated the offense that would indicate risk and
Who says
danger.
there, what law says there must be facts that postdate the offense?
That's Doe 24-341 talks about that.
Says there must be facts that postdate the offense? If you, do you have a page site?
I'll read from, this is from a unreported decision, but while what Doe 24-341 requires is the examiner consider all the factors bearing on the offender's current risk, including not only past convictions, but recent events and conditions that suggest decreased as well as increased.
Okay. So if there's evidence of recent conditions that suggest decreased risk, the board has to consider those.
Yes.
But what you said before was that the board has to point to some post-conviction conduct in order to justify continued registration.
Well,
and that's what I'm
that's
asking about, because if there's law to support it, we should know about it.
That's among the things they have to consider, but they also, this particular decision was deficient in that it didn't discuss any of the predictive value of the offense, such that this individual, 16 years later, continues to pose a risk and danger such that he needs to continue to register. Not only that, we had in this case, we had an expert opinion that was essentially on the very issue that the board is meant to find. And we have Dr. Brown saying that this petitioner presented no cognizable risk, which is...
Didn't the good doctor, though, assume that the first two convictions were for non-sexual offenses?
For the purpose, as I pointed out in the reply brief, for the purpose of coding, sir, the good doctor, in his testimony, indicated that he did consider those, but he did not consider them for the purpose of coding. And I would submit...
Coding for the
static 99.
So isn't that a mistake?
It may well have been a mistake.
But he said that if he had considered them as indecent assault and batteries, then the risk would jump to 8%. Is that nil? I mean, is 8% something that requires the board to relieve him of his registration obligation?
No, but his opinion, and obviously the SORB jurisdiction is not, just because you have an opinion, that's not dispositive at all. But in this case, the hearing examiner, I would submit, rejected this opinion without an objectively adequate reason for doing that. And I would submit also that the board now states that, oh, well, the reason for rejecting this was because he didn't consider these convictions. That was one of the reasons that's disingenuous, in that the hearing examiner herself didn't put much stock in the static 99. And I would, as an aside, I would suggest that there's some question as to whether the static 99 in this particular case, although he's not a juvenile, the static 99 does not apply to juveniles. He is an emerging adult, and so there's some question. I mean, I realize we're in a gray area where Mattis was just recently decided, and the SORB regulations don't reflect this. But there's some question as to whether the static 99 would have applied at all.
Just a quick question on, there's at least a suggestion in the record that his past offending is one way or another related to his diagnosis of autism.
Mm-hmm.
Isn't that fact largely irrelevant in the absence of expert testimony that someone either ages out of that or through treatment can overcome the kind of impulses or failure to read cues that led to the offending in the first place?
Well, there was Dr. Brown's opinion, both in his report and in his testimony at the hearing, did touch on that and said that while neither autism nor ADHD, both of which afflicted the petitioner, while they don't go away, the symptoms do dissipate. And as I say, that was in his, both in his report and his testimony.
Didn't he disclaim some degree of expertise on autism?
He did not term himself as an expert, and I think that's in the hearing decision that he wasn't, but that he was familiar with that, and I don't know if he termed himself, I mean, he's an expert as to testifying, as to risk and whatever, and I think it seems as if he had enough information about that to be able to provide that.
Thank you, counsel. We're going to have to leave it there. For the record, I disagree with you strongly on one point, and that's about your ability to remember numbers of cases. You seem quite adept at it.
Just those two, though.
Good afternoon. May it please the court. I'm Roxanne Greenaway for the SORB.
Could you just tilt the mic towards?
Sure. Tell me if you can hear better. Roxanne Greenaway for the SORB. First, I just wanted to point out on a point that's been raised with regards to termination. It really is no different than any other classification. The only difference is if at the end of that proceeding, a hearing examiner determines that the person sitting before them does not present a cognizable risk, and they have that motion, they can terminate that obligation to register. But
I was a little confused by the hearing examiner's citation of Regulation 1.29. I thought this was a proceeding under 178G.
well, normally when you go to the 178G is the statute, but then the SORB has the regulations where they follow through
Right,
with
but
regards to
178G is
implementation.
termination, 1.29 is reclassification.
Right.
Before there's a final classification. So maybe the structure of the proceeding is not much different once the offender carries his burden of coming forward, but, well, tell us, is there any difference?
I don't think that there is a difference. I think in any proceeding, the SORB is going to bear that burden of proving by clear and convincing evidence that the person sitting before the hearing examiner, the offender, presents a particular risk. In this particular case, that risk is low, that the hearing examiner decided was a low risk and is a low degree of dangerousness. And the hearing examiner bases that on all of the information that's presented at that hearing. And the case law is very clear that even though some factors are going to apply based on the crime itself, they do not cease to apply because of a passage of time. So what you have to look at is whether the overall, when you look at the overall decision of the hearing examiner, whether the factors that the hearing examiner applied are supported by substantial evidence in the record, and that's what you have here. With each particular factor that the hearing examiner applied, and I tried to put it in my brief where you can find it in the record, it's supported in the record. So what you have is, you could even look at the hearing examiner's decision with regards to her taking into account the datedness of some of the factors, because she does give moderate weight and minimal weight to some of the factors based on that. So it's not that the hearing examiner did not take this into account. I think Mr. Doe is obviously, he wants to be terminated, and he disagrees with the hearing examiner's decision, but he based that mostly in part on his offense-free time in the community, and that is, no one factor is dispositive. And while the hearing examiner, when you look at the decision, the hearing examiner gave full weight to that factor, and Doe is not entitled to more than full weight. That's the most he gets for that particular factor that covers that circumstance in his case. But he does have other circumstances in his case, including his sex offender history, and the case that my sister attached to the reply brief, 2751 in 2022, that case is an unpublished, but it does indicate that there is nothing in Doe 24341 that suggests that a hearing examiner, let alone in every case, was required to identify some post-conviction development that reflected negatively on the offender before denying the motion to terminate that duty to register. So it is no different than we have here. What you have is the hearing examiner looked at this particular case, and in regards to Dr. Brown did not score the juvenile offenses that were lesser included offenses. And on top of that, when you look at his report, although he claims to discuss the SORB factors, you will see it's quite short, and there is no expanding on any of the SORB factors that would not apply now as opposed to applied before. So
you're offering some good reasons why a hearing examiner could have disregarded Dr. Brown's testimony, but the hearing examiner herself did not articulate those reasons.
Well, if you look at the hearing examiner's decision, and I actually looked at the language, she indicates in the whole decision, it is on 79. So this would be record 79, ADD 79, I'm sorry. And at the end of that, when she's given the conclusion, she says, I agree with Dr. Brown to the extent that the petitioner continues to pose a low risk to reoffend and a low degree of dangerous, as I have detailed within this decision. So I think you have to look at the entire decision, not necessarily that factor itself, only the discussion of that factor in the decision, because the hearing examiner is saying, these are the things that I disagree with, but look at my entire decision as to why I'm saying that this person presents a low risk.
Could I fall back on a basic question?
Yes.
And it stems from the fact that most of the SORB cases we see are level 3 trying to go down to a level 2. Occasionally we see a level 2 trying to go to a level 1. Speaking for myself, this is the first time in 15 years I've seen a level 1 trying to go down to a level 0. As a result, I haven't thought a lot to date about the burdens of being a level 1, where there's nothing on the internet, as best I know. There's the burden of registering and updating that, et cetera. But what are the effects of being a level 1 sex offender, again, other than the burdens of registering, in terms of the public's ability to access the information? How does it affect someone's life?
Well, the public does not have access to level 1 information. I do know that in circumstances, for example, if someone's applying to a daycare, because we have that whole case here in Massachusetts, if you're applying to a daycare, the daycare runs the background of the people who are applying as employees, because they're going to be exposed to children. And so if you are level 1 with a sex offense, that would likely be disclosed to that particular agency, is my understanding. But other than outside, and those I believe are by statute the information sharing that you can do, but outside of those parameters, the public does not have access. The police has access. That person registers once a year But that's all.
What about the two Hansen articles
With regard,
showing desistance after 10 to 15 years?
well, I think it's no different. I shouldn't say it's no different. When you look at Factor 29 takes into account not only 10 years, but up to, it's every 5-year increments. And so desistance is one, again, that will go to one of those factors. That will go to his offense-free time in the community. But to say that because someone is in the community for a particular period of time, they no longer present a risk, that would be saying that that one factor is dispositive of risk regardless of anything else that applies.
Well, we have two articles talking about the risk after 10 to 15 years declining to that equal to someone who'd never been convicted of a sex offense. If there were a scientific consensus that that were true, would the board at some point be obligated to bring its regulations into conformance with that consensus? And essentially give Factor 29 dispositive weight after 15 years or whatever the number was?
I do believe the board is updating its factors currently, and it is looking at the current research, and that's always part of updating the records. But outside, I'm sorry, the regulations. But outside of that, you do have Factor 37, where people can present updated scientific information that's emerging that a hearing examiner may be able to take into consideration in that decision.
So your answer would be there's no scientific consensus yet?
Not that I'm aware. And to be honest, Your Honor, you're married to the record. You're constrained to the record. So you can only look at what is in the record before you. So the hearing examiner, while there may be people saying that there's studies out there, unless you present that to a hearing examiner in your hearing, it is not part of that record and it's not up for consideration. And then the last thing I would mention is, or just respond to is, I know my sister mentioned the emerging brain and so forth. It's very clear from the record that this was an adult. Dr. Brown acknowledges that it was an adult. The study that was presented is only based on individuals who committed their crimes under the age of 18, which is not this individual. So, and the other thing with the case that was Mattis, I believe it was, that was just published, it is in a penological setting. It is not, there is nothing that has been presented in this record that links the emerging brain to risk of reoffense, sexual risk of reoffense. So unless you have that before a hearing examiner, they can't speculate.
Can I, before you move on, the petitioner's attorney said here today that Dr. Brown, putting aside whether or not he had sufficient expertise to speak to the issue, he did get into the condition of autism and the extent to which the behaviors associated with autism dissipate with age. So is it accurate to say there was no evidence here linking the age to this? Because if the autism is causing the sexual offending and it dissipates with age, isn't that evidence?
But I think the record is actually clear on the other end. Dr. Brown does not say that it causes. He said that they were contributing factors to the offending insofar as, for example, his impulsivity. But he never says that because he is autistic and so forth, he committed these offenses. And as he gets older, he's not going to do it because the effects of, or the symptoms or the characteristics of his autism is going to dissipate over time. That is never said here. He is absolutely clear that there's no causal link between autism or Asperger's or ADD and sexual offending. And I would rest on my brief for the rest. Thank you very much. I ask that you affirm the hearing examiner's decision.
Thank you both very much. The case is submitted, and that completes our sitting. Our thanks to the court officers, the law clerks, and we are adjourned.